leave to mention a mandamus appeal. Now, this matter is already figuring on Lordship's list, but the difficulty is this. When I'm already been approved by the government, and a third-party appeal has been preferred, it is only being kept pending. I'm not pressing hard before this side of the vacation. Any day subsequent to...
Please mention the other side. You mention after reopening.
No, I've already indicated. Lordship can believe me. Only any day, Lordship can.
So therefore, after the holiday, you mentioned, we don't know how things will be after the holiday. You mention after the holiday.
No, I'm not pressing hard this side, Lordship.
Therefore, we said, if there is no immediate order which is required to be passed, please mention after the holidays.
Yes. So I'll be coming on the
yes. You can come any day. Yes. What do you on? Which exam? What is your grievance?
After the hospital event notice period for filling up the form was over. Thereafter, after the authority changed the recruitment process, the means selection process.
So they have allowed more people to apply.
In the midst of the...
I've understood what you're trying to say. We are asking about the facts. The fact is they have allowed more people to apply.
What
is the problem?
What selection process?
Sorry, you have approached the tribunal.
And I filed the restriction
when the advertisement was issued.
Advertisement was issued in the month of August.
Then sorry.
There are changes done in the month of November, but we have raised objection. But we have filed the restriction or my restriction is 15th of this month.
All right, give it. We'll see. Next coming Wednesday.
Can application
Wednesday is the mandamus appeal day. Listed on Wednesday.
Well,
it can be done on Friday also. Monday, Tuesday. He's saying rising out of single judge order. So Group 6 is not Monday, Tuesday. Monday, Tuesday is WPST. Both. Oh, intra-court. This is intra-court. Yes. Friday.
Well, I have to mention, can application with connection of WPST 181, which is the earlier disposed, but for modifications, applications. Your Lordship judgment is the for modifications application, can application.
What modification? There is some correction required.
Yes, judgment.
What is the error? Tell us.
No, typing. Judgment is the modifications.
Then you wait. Yes. After the holiday you mentioned.
But
it's not possible this side. Sorry, not possible this side. Yes.
Unprecedented prayer, innocuous prayer.
Nothing is unprecedented in court.
Very innocuous prayer also. Item 61, if it is taken up before the recess, then I have no other. Kindly accommodate me at one.
He's asked some friend to be here.
No, one difficulty. Arranging out of this judgment, contempt has been paper. Contempt has been fixed at 2 p.m. before the line single bench.
At 2 p.m.
At 2 p.m. contempt has been fixed.
For compliance or for what?
For compliance. A policy decision has been overlooked. You have a policy decision that has been overlooked by the line.
Have you informed the other side?
I have informed.
Then we can take up what time we should take.
1 p.m. No, that was changed.
1 p.m. will.
1 p.m.
Please inform us. If they are not there, we will not take it up. Yes.
61. I will inform them.
Item number 1.
My lord, I am appearing on behalf of the appellant, my lord. My lord, your lordship in the earlier occasion directed me to take instruction regarding to addition of party filed by the respondent number 4 of the litigation in this instant appeal. Lordship, earlier occasion directly I am appearing on behalf of the Life Insurance Corporation of India for taking instruction regarding the additional party, which have been filed by the respondent number 4 in this appeal, my lord.
What is
But-
the issue? Please tell
The
us.
issue is being everyone dissatisfied with the order passed by the Honorable Single Bench on 8 January 2025. We have preferred an appeal, and thereafter appeal, therefore, Honorable Division Bench have stay the interest portion, which is interest portion, and disburse the 1/3 share to each of them, my lord.
No, what is the proceeds is in respect of what claim?
Return dues, my lord.
Oh, service arising out of service
Yes,
due.
yes. We have already released 1/3 share to the petitioner and 1/3 share to the mother-in-law of the petitioner, and 1/3 share of the amount will be kept with the
Petitioner is
Petitioner
petitioner
is
respondent number 1.
petitioner respondent, who is the wife of the deceased.
wife
Wife
and,
of the
and 1/3 to the mother-in-law.
1/3 is the mother. As per,
So the remaining third,
even
1/3
as
is
per direction of the one, as per the Honorable Single Bench, direction of the Single Bench, we have the amount reserved with the LIC interest bearing part, my lord. And now they have filed the additional
remaining 1/3 is for whom?
for son.
Well, the
Son.
Son of the
Son is before us.
son is before this court with an application. Since there was a direction from the erstwhile division bench, since there is a difficulty of disbursing the amount to the person, to the son, you come up with an application. I am with an application. I am already appearing for the mother, and at the same time, I am already appearing for the son with an application. Now, since my payment portion is left with regard to the 1/3, this is one aspect of the story. And second is with regard to a accidental claim of 50 lakhs, which is due and payable to all of us, which is still being unpaid as of today. First, with regard to the payment,
Let us see the single judge's
yes,
order.
kindly have a look. Lordship will find the same from 56 of the stay application.
The order is of 8th January.
8 January 2025. May I read for your lordship?
Oh, we are going through, please.
Okay.
এই ফাইলটা দেখো কোথায় আছে পেন্সিল দিয়ে লিখে দিচ্ছি বলে দিয়ে দাও হ্যাঁ
So you were a writ petitioner or you were not a writ petitioner?
Initially, this wife came before this court, knocked the doors of the court that my husband's retired dues are being unpaid. His husband was ablaze while he was on duty, and subsequently he came before the court that you pay my retired dues, whatever due and payable to us. Now, subsequently, when this matter was moved, the mother-in-law came in the scenario asking that I am also being entitled to being paid with a certain sum of the money. Be that as it may for the present, we decided to be paid 1/3 each with me, my son, and mother-in-law. No difficulty with
On that there is no dispute.
Not that on that there is no dispute. Now the difficulty accrued the moment with regard to the son who is being unpaid and before the court with a direction from this Justice Pal that you come with a proper application to raise your claim. Since there is already a direction before the court, but since I was not a party before the single bench, therefore my claim could not be raised in a proper voice. That is the reason why I am before this court today with an application first. And second is with regard to the, if
No,
you
so-
kindly have a look,
Insofar as the dues are concerned, if there is no dispute that all are entitled to 1/3, then what is the thing that you have to be heard about?
I'm not being paid. If I am being paid, I'm moving on.
So only compliance with the single judge's order.
Another aspect, another aspect, there is a leftover of dues of 50 lakhs from the Oriental from which learned friend is there.
No, that comes later.
No, this is
Well,
also part of the scenario.
we don't know.
So,
First,
this is
we
the
are concerned with the single judge's order only.
single judge's order
Well,
reflects
Kali,
everything.
And the
page
order
57.
is passed on a writ petition wherein a specific prayer has been made. Now we'll confine to that. We'll not travel
I'm
beyond that.
coming.
Sorry.
That single judge's order do confines all as a whole.
No, sir.
Yes, yes. Doshi, kindly be. That is not our insurance. That's a group insurance.
Sir,
Which I see.
sir, come to page 23.
Page 20.
23, yes. Of Can 1. The only relief is for retirement benefits and terminal dues and compassionate appointment, nothing else. That is the scope of the writ petition.
As retirement dues in
Yes.
says, and Doshi, kindly be. They are
Not insurance claims. For that, we are not stopping you.
Claims come within the ambit of the group
Sorry.
insurance of the LIC, not ours. This is kindly have a look. Their own chart, LIC's
While-
chart, whatever left and due is payable. I see it, Adina.
There is no prayer for this.
Just 1 minute. I'm trying to convince. In fact, there was indication of the erstwhile division bench to that effect. Loshi, may I have a look?
Maybe
Kindly.
that may be. We are not saying there is no earlier order that indicating this thing. We are on whether it is to be included in this claim or not.
That is the reason why division bench inducted him to come in the scenario.
There is an order.
Yes.
What is the date of that order?
Lordship will find the order of. Kindly have a look. This, yes. Kindly have a look of the order first of 28th of August 2025. This, yes, of Justice Pal.
28 August.
Come in.
ওটা না, ওটা না।
28th of August.
28th of August 2025, Lordship was found. Supplementary affidavit seeking implement of Oriental Insurance Company. This was given birth of the erstwhile order of Justice Chakraborty. এটা নয়, এটা এরপরে
Oh, this.
that lordship will find from 30th of April order.
Oh, 30th April 25.
Which gives birth-
25.
25, which gives birth to this for the application to be made on behalf of the corporation itself.
Let us see. Just
Yes. Take it. এই তো 30 এপ্রিলের পরে 30 এপ্রিলের পরে তো 28 ওই
আমার লিবার্টি দিল যেটা
ওটাই লাস্ট তারপরেই তো বুঝে
তাই তো, হ্যাঁ ওই বইয়ে থাকবে।
বলছি।
ওটাই দেখছি দিয়েছি
Lordship is going around with 30th of
So according to you, apart from the 1/3 payment, there is a due under the group insurance scheme in view of the fact that he has suffered an accidental death.
accidental death.
Yes.
My lord, we are ready to pay the 1/3 share. My lord, kindly travel to turn page 57 of the Honorable Single Bench Order, my lord, paragraph 2, my lord. Page 57. My lord, may I be permitted to read, my lord?
Why? What is the problem?
My lord, 1/3, as per the direction of the Honorable Single Judge, my lord, it has to be kept with the 1/3 share in the LIC LIC interest bearing fund, as the son is when the son is a major and is able to look after himself, that time LIC will pay the amount to the son. That is a clause, my lord. Therefore, the LIC has kept 1/3 share to the LIC interest bearing fund. But my lord, as per now, as per the instruction of my client, after he has filed the additional of party, my lord, for instruction of my client, LIC is ready. LIC is ready to pay. If your lordship will direct the LIC will ready to pay 1/3 share to the son, my lord, but he has to submit before the LIC authority to production of age proof, bank details, KYC, PAN card, and declaration of health.
So why, if you asked him why will he not give it?
But if they will submit, LIC.
When did you ask him that you give this? We are waiting for this to make payment to you. Why do you need the court's direction for this?
But there is a, well, kindly see the order, my lord.
What order?
Order.
You
order
are saying that we have to pay it,
it
but
will be- well-
we should direct him to give these documents. Why?
My lord, order. My lord, Honorable Single Bench has directed me to keep the 1/3 share to the LIC.
How many
fund, my lord.
times you will say the same thing? When you know that certain formalities are required from him, why you have not asked him?
Well,
Why do you need a court's direction for this?
They have filed a representation, my lord.
What is
They
it?
have filed a representation before the LICI for releasing his fund on 1st April 2025, my lord.
So then why you have not done it? Why you have not done it?
Well, as per the direction of the Honorable Single Bench, therefore,
Therefore, what is this? Litigation for the sake of litigation.
My lord, we are ready to pay, my lord.
Then if you are ready, what are you waiting for? That is what we are asking you.
Well, that
Since the single judge's order, what you are waiting for?
single judge order says that the amount should be
Now again, you will say that for the third time. What are you waiting for? We are asking you.
if they will not represent, they will not submit any document.
When did you ask them for the document? Show us that you have asked and they have refused to give.
They have filed on 1st April 2025. my lord.
When did you ask for the documents that they have not given? You are saying we should direct them to give the documents. When did you ask them to give the documents? Show us.
Well, they have right.
This LIC is behaving like this. I mean, very unusual.
Also,
You have challenged a single judge order. You are saying we want to pay it. And then you want an
I'm
order.
only-
What order you want? What is this?
only the interest portion has been stayed by the Honorable Division Bench, my lord. And 1/3 amount we are ready to pay, my lord, to the son.
You know you are not. If
The
you are ready to pay, you would have done it by now.
Mr. Last occasion, well, your lordship directed me to take instruction, my lord. That's why I'm ready to pay, my lord.
This is a most very unfortunate circumstance. He is your employee.
My lord, I'm ready to
He
pay.
has what kind of attitude?
Well, I am ready to pay 1/3.
No, you are not. We are gathering impression. You are just interested in litigation.
Oh, my lord.
Yes.
But as per
We may
direction of the
record
Honorable
that
Division Bench, as per direction of the Honorable, I have already paid, my lord, 1/3 to the
Then why that 1/3 is being withheld for so long a time?
my lord, as per the order.
For what? Again, you will say as per order it is to be invested. Fourth time you say that. Who is stopping you from making the payment?
Well, I'll pay, my lord. I'll pay.
Necessary?
I'll-
Yes.
Yes, sir. Lordship, one issue that is not informed properly is that out of the total components to be paid to the petitioner, one component has to come from the oriental insurance as part of the group personal accident.
Yes, that comes later. First is his terminal dues and retiral dues. That will come later. They are saying we are ready to pay and they are in appeal. Wonderful submission being made by an entity like Life Insurance Corporation.
My lord, we are not. Well, we are ready to pay, my lord. I'm only concerned with the interest portion, my lord. Nothing more, my lord.
You don't want to pay interest.
that interest portion will stay by the honorable division bench, my lord.
So you don't want to pay interest. Then why you have not paid the amount without the interest till now?
Well, as per the,
Eh,
my lord, I will pay, my lord. Right now, I will pay, my
That's good.
You clear off whatever is admissible, then you come, we'll consider the rest of the things. Today, a submission is advanced.
Date.
You are getting a date.
21st. Great.
You grant adjournment in any case without date.
Grateful.
So
Cheers.
that is the problem with suggesting a date. Some lawyer has to object to every.
Then 20 would be better.
Tell us.
20 would be fine. For us. So, I leave it to the court.
21st, we can have it on
20th Lordship is posting it to be mentioned at the same heading.
21st. Yes, 21st. Under the heading.
Same heading, my lord. She is a cancer patient. I'm not. She is a cancer patient, my lord. Of stage 4 cancer. Can you believe me? I never lied unnecessarily.
Only if it is necessary.
With the quality. I mean, kindly to be mentioned would suffice for our purpose. At least you will get something.
2 p.m.
2 p.m. Grateful. My 20th.
We appropriate it.
21st.
21st.
20th. Oh, so
Oh, সেই জন্য 20
oh, then 20th is the WPSTP. All right, 20th.
Lordship is posted at 22nd.
20th.
20th. 20th 2 p.m. 20. Great.
Item number 2.
I'm learning this. 20 means 20.
20 means 20. 19 মানে 19. Lordship is learning nowadays. My lord, only one thing. Lordship, kindly grant me a leave to amend the cost title since you're all.
And advocate. Let it be done by the department. Department to make.
Oh, তাহলে আর করতে হবে। ঠিক আছে।
Department to make necessary. That'll be modification in department.
It is department now.
So our duties are given a go by. Good.
The petitioners. Order below at last, my lord. The respondents did not file any reply to the original application before the tribunal.
Can to tell out.
I think it requires to be heard, my lord, on affidavit, if your lordship so pleases.
Now, I've got preliminary objection about the maintainability of the repression. The kindly see page 1.
My lord, my lord, then, my lord.
Before preliminary objection, you will make submission. Yes,
The kindly see
page.
page 166. Hearing concluded on 2nd March 2020.
Six.
Bottom one.
You are referring to the impugned order?
Yes.
July 2020 order is being challenged now.
My lord. Section 14, Article 14 of the Limitation Act. The petitioner, my lord, went to the wrong forum.
Where did he go?
On the notion that
Where did he go?
but before the tribunal for substitution, because before pronouncement of the judgment, my lord, the petitioner's husband died. Then, my lord, after when tribunal took up the matter, then said that no, the judgment is all right, you have come here. Okay, it kept it pending. Then, my lord, the petitioner, my lord, got the idea that under Order 22, Rule 6, if the hearing is concluded before the death of the petitioner and the judgment passed after the death of the petitioner, then the judgment is not a nullity. To that effect, I have annexed a judgment also, my lord, at page 179.
So you are saying that in between hearing and pronounced delivery of judgment,
My lord, she went to my lord, the tribunal for substitution on the.
you are repeating the same thing. We are trying to make a query, you are repeating the same thing.
My lord.
Is it your submission that in between March and July, the applicant passed away?
Yes, my lord,
And thereafter he went, what did you do? You went for substitution
substitution
after the judgment.
after the judgment. On the wrong
Where
notion,
is the order passed on that application for substitution?
order is not passed, my lord, but the matter, while the matter was kept pending, my lord, then, my lord, the petitioner has got the actual position of law that under Order 22, Rule 6, it is not a nullity, the judgment is not a nullity because the judgment is all right under Order 22, Rule 6. Then, my lord, she has come to before
So
the.
where is this fact? We are asking you, where is the substitution application?
Yes, my lord. My lord. I will give you. At page 166. Page 166.
The 166 is the impin order.
No, sorry. Sorry, my substitution application key 10. 152, my lord. No. 154, my lord.
After the disposal of the original application, tribunal has no jurisdiction
My lord,
inside the substitution application. Because of the order 22, rule 6.
So what is the number of this application that you filed?
MA 52 of 2021.
What is the order passed on that application?
Order has not been passed, my lord. My lord, subsequently during COVID period, my lord, then step could not be taken by the petitioner, my lord. Then he got the idea from her learned advocate that no, the judgment is all right. You challenge the judgment. You need not go to the tribunal for pursuing the same.
So how long it has been pending? Whether you took steps any before the tribunal, whether any date was granted, or you have filed it and left it for 5 years and then come to this court, you have to show.
My lord, then
So there is a gap of around 5 years. Therefore, we are asking you, what
On
happened
20
after filing the substitution?
21, my lord, I filed the substitution application. Then, my lord, I could not collect the actually any order of the substitution application from the tribunal.
Then
Court
you,
was not functioning due to COVID
from
period.
21 to 25.
No, not 25.
Is that your summation?
Petitioner is a widow, not illiterate, widow having no knowledge.
We know that. You have already said that he passed away.
My lord, in the
You have-
judgment, my lord, Supreme Court specifically stated, my lord, reported in the year 1983, one Supreme Court cases, page 184, that the petitioner, in that case also, the petitioner was illiterate widow and having no source, my lord, to gather knowledge, the actual position of law. So delay occurred. In that case, my lord, following that judgment, my lord, Sundar Chakraborty judgment, the division bench, my lord, he had held that where 45 years delay was condoned and directed the authority concerned to consider the case of Sundar Chakraborty, whose husband was a railway employee.
Sir, you are a different kind of person. You have taken steps. You have filed application before the tribunal.
On the wrong notion, my lord.
So you are not someone who is illiterate, who doesn't know anything. You have taken
My lord,
steps.
My lord,
Therefore,
advocate has no knowledge.
you are only interested in making a one-sided submission.
I'm sorry, my lord.
Again and again, we are
Extremely
asking you
sorry.
what happened after filing the MA.
Extremely sorry.
What happened after filing the
No
MA?
order was passed, my lord. It before listing of the matter, then my lord, the petitioner got the idea.
What do you have an idea? It is still pending. It has been dismissed. What happened?
No order was passed, my lord.
So it is still pending.
Yes, my lord.
Where have you said that the MA is still pending? Show us that one environment. How it can be pending for 5 years?
My lord, page 18, my lord.
Page
18.
paragraph.
Paragraph 25, my lord.
Where it says that it is still pending, please read in paragraph 25 that it is still pending.
I beg apology, my lord. I should collect the orders, my lord. Whether any
So
order
when
was-
we are making query, before hearing us, you start making submission one after the other.
I am sorry, my. I am sorry. I
That
beg,
is the only way it can be resolved.
I
You have to show what happened in the MA.
I beg apology, my.
Learned advocate for the writ petitioner. We are asking you some, it could have been done in 2 minutes.
I am sorry.
Unnecessarily you are.
I am sorry, my. Extremely sorry. My lord, in the case of Shraddha Chakraborty, the husband was passed, my lord, by
Alright.
Kate, my lord, after
For
10
the
years,
next.
she approached Honorable High Court. Dear to my lord, I am obliged, man. I am extremely sorry, man.
Please, every observation is not hostile.
Yes, man.
Observations are made so that you can respond.
Man.
It's not that we are trying to
Right.
throw you out.
Man.
Listen to what we say.
Man.
then you
Yes,
respond.
yes, man. Sorry, man.
No need of.
I beg apology, man.
No, sir. No need of begging apology.
Item number 3.
Item 3, my lord, I appeal for the petitioner. My lord, this matter, my lord, I am in favor with the order of the tribunal, where the tribunal, learned tribunal, allowed my petition and asked the DHS to, my lord, to grant me the study leave. My lord, I have no other option. I moved the contempt application. My lord, the tribunal is not functioning, and your lordship has heard that matter, and your lordship directed whether any writ petition is filed by them or not. And my instruction goes, my lord, as of now, he has not received anything, so I do not know whether any writ petition is filed or not. And my learned senior friend can, my lord,
I have not been able to, this order has not been challenged, but the order has to be complied with. But according to my understanding, although the instruction is otherwise, the only difficulty is that because of the OBC certificate, we have started selection process stopped. Then, but give me some time so that you can release immediately.
How much time? Give a reasonable
At
suggestion.
least 3 months time maybe give me.
When your course has started?
my lord, in month of April. My lord, a letter has been issued by the NRS, my lord, asking me to join, otherwise my candidature would be cancelled. But that is also there, my lord. And my lord, it's not case of OBC, my lord, any other thing, my lord, your lordship may consider. I won't be leaving the job. I will be in the government service. I will be doing the study leave, and I will also, my lord, attend the patients during my course. So, my lord, it's not that I will be.
What is the order of the tribunal?
My lord, the order of the tribunal is at page 128.
In August, you were required to accept within 7 days.
7 days. Malad.
Now it is 3 months.
We cannot defend, Malad. Right.
We can't allow you to wait for 3 months. He will miss everything. The order will become redundant. It will be
No,
of
order has
no
to be
consequence.
complied with. Order has to be complied with.
Then we must do it immediately. The pursuant to the law. In the same position.
Motion series.
Look at the same heading. Item number 4.
In this matter, I am for the petitioner. This is my affidavit of service. Again, the refusal, non-grant of the interim order, my lord, with regard to the pension is concerned, even after the superannuation. The interim order, my lord, after page 63. The facts are recorded properly, my lord, but in the operative part, it has not been granted.
What is wrong with this order?
This order is wrong, my lord, on a part because I have prayed specifically for the interim order to grant provisional.
Final relief.
No, my lord. In provisional pension. Kindly come to page 31 of my relief of my OA.
You may couch your prayer in any language,
Yes.
but in substance, you want by way of interim relief. What is the final relief? You want payment of pension.
In an interim relief, my lord, I can only pray for provisional. In a final relief, I can go whatever the pension fixation will be because I have no.
So, according to you, what is the provisional amount which can be paid? Different from the final.
Any lump sum amount for my survival.
What is this?
Because I
Under which provision?
Under which provision, my lord?
Yes.
Yes.
There is an issue whether you were ever the CDPO or not. They are saying you are an acting CDPO. You say that I am entitled to scale 14 from such and such date. This issue, unless it is decided, what can be paid to you?
Correct. At least supposedly, by
On
after
what
the
head?
retirement.
On what head, sir?
No, after the retirement, what would be how the person will survive, my lord? That is the mute question of law. I'm on Article 21 of the Constitution.
If you are not a CDPO, will you get a pension?
Even though I'll get, my lord.
Under which provision? Show us.
Kindly come to page.
Even if you are not CDPO, you will get a pension.
Kindly come to order 30, page number 38.
Yes.
and I was getting the scale number 14. It is a settled prop.
You are not on that. You may be getting any payment. We don't know why and how they are paying you. The point is, if you are not a CDPO and you are an acting CDPO, you will get a pension. How do you say so? Tell us. Where is the order posting you as acting CDPO?
Kindly come to page 38, Mallet.
Yes.
The third paragraph, Mallet, deals with the entire proposition of my argument. May I read, Your Lordship?
This is of 2016.
Yes.
So where is your prayer for the interim relief? What is the interim relief that you have prayed for?
Yes. Kindly come to page 38. Sorry. Yes. No, not 38. It is about 31.
When did you retire?
I retired, Mallet, in June 2025. Sorry. 30th of June 2025.
Where is that?
That recording is itself in order, Mallet. The third paragraph.
So nothing is being paid to you. Where have you said so?
At page 27 of my paragraph 4.9. And 4.11.
Who is appearing? You are appearing.
Item 4.
Who is appearing?
Mallet, generally, my learned senior friend is appearing for the state of West Bengal.
No, no.
But he is
No, he is not. Only cases which are assigned, then only he appears. It is not that generally he appears.
That thing, Mallet, I have already served. So therefore, to whom it has been
Whom
assigned?
have you served? Therefore, we are asking.
No, I have actually served, I submitted, Mallet. I served to all the respondents.
Serve on the learned government leader.
Yes, I'll do it.
Let copy of the application be served on the learned government.
Tuesday. Please, sir.
That side of the case.
Big law.
That side of the case.
No, no, Tuesday.
Days.
Absolutely get pension.
Hmm?
Absolutely get pension.
He may not get skill 14. May not dispute.
Item number 5.
This is my this is my affidavit of service.
My lord, this is the appointment of compensated on the date of my father. My lord, kindly see, I draw your attention. That is annexure P3, page 26.
Where is the rejection order?
My lord,
Where is the rejection order by the authorities?
by the,
Where is the rejection order by the authority?
that is the, my lord, page 30.
Page, before taking out the matter from the disturb date, tested from other institutions, although it is not found by. The page 2. The picture was applied to the medical officer. Please say. Appointment corporation card, we have given
No,
the
no, it's
medical officer.
It's a computerized mistake from typing by the clerk. No, I, tomorrow.
You are shifting the onus on your clerk.
No.
No, you said typing by the clerk.
I understand.
Before filing, you are not obliged to go through the things.
That.
Why you are saying clerk? This is not fair. You should own up that you have committed a mistake rather than shifting it on the clerk. You should say that you have committed a mistake. What is the clerk to do? Clerk has no responsibility for this.
Well, I will change it tomorrow. Let it be
That we can do. Don't say that clerk has done it. That's not.
tomorrow. It will, but in the original copy, it is.
You file a reply. You have filed a reply before the tribunal. Because this 2016 amendment would have come into force.
What have been considered?
Huh?
Has been considered.
No, no.
Initially, mother applied. Then subsequently,
Mother was eligible.
mother was eligible, mother applied.
Oh.
And mother application was granted, and then son became major.
In the meantime,
In the meantime, he filed an application. Then mother went gone to the department, and then government. Government rejected the appeal, page 30.
That candidate was 15 years, 27 days old. This is the only ground for rejection.
Because he was a minor.
Minor at that time, that is admitted position. But he is now major. Now major, my lord. And not only that, as per their requirement, we have complied all the measurement, education.
2016 circular has been considered.
My lord, kindly see.
no, did you file a reply before the tribunal?
No.
Then you file, we'll see. Let opposition be filed. in third week of January.
20th January. Item number 6.
All these cases, because in all these cases, if the date for filing of opposition by 12th and then third week date in the meantime. Yes,
Order passed wherein they based on the 90% family income. On the basis of the report, your lordship kindly see what is the report? Page 71. How they have calculated 90%? 71. 71. 73. 71. Sure. একটু আমি যেটা বার করব। A report of inquiry committee such and such 90%. Inquiry report. Where is the inquiry report? They have not found this.
Kindly see page 73.
তারপরে কি বলছি আমি তো 72. Then report was prepared 2017. Date of date 2013. Long after 4 years, they have calculated. But they have not taken into consideration, Milord. They have submitted the mother who is living separately. I have got the document, Milord. That has not been taken into consideration.
where is your OA? Let us see your OA, what you have said.
Report your lordship kindly see. There is no reflection.
Where is annexure F of the OA?
Okay.
Yes. Come to page 32. Averments made in paragraph M.
M.
Yes, paragraph M.
Page 57.
No, sir, we are asking where is
F. That is 9th of August 2027.
So where is the letter submitted by you? Why you have not placed it before the tribunal? And why you have not placed it here? She submitted her monthly income out of family pension and retirement within the time frame. Where is this letter? Why you have not, why you have withheld this?
Page 59. Page 59.
No, sir, that is not the reply. That is not the reply.
It is admitted fact, Miller, the mother is not living with us.
We are asking you a specific query. Unless you meet that query, there is no scope for making any submission. You say there is no basis for arriving at the amount. You say you have given the income, but you don't annex it. Whether it is a relevant and material fact or not, tell us.
আগে খুঁজে পাচ্ছি না একটা কোথায় এফ কোনটা না না
You file a reply there.
page 52 51 51 he is saying that mother was not saying kindly come. It is in vernacular. I am explaining.
Page
52.
What is the date of that document?
No, page 52 is a he is saying that the mother was not residing with the son.
No, we are not on that. How that is relevant? That is not relevant.
That document is not,
Residing or not residing is not relevant. That is not relevant.
that document is not.
We have seen the format several times. It says give list of all dependents, whether residing separately, whether residing with the family, the income of everyone, everything has to be furnished. If they are separately, that does not mean it does not have to be furnished.
Page 51 52 in Bengal.
No, where is the reply to 9817? You have specifically said that you have given a reply within the time frame. Yet you have withheld it from the tribunal. You are withholding it from this court and you are saying there is no basis.
But it is fact, Miller. No reply got that.
Suppression. So suppression. Suppression from the tribunal, suppression from the school.
We can put the written objection in the OA application at page 75, my lord, it will be revealed that. That 2013, your lordship kindly consider this. The Supreme Court says, my lord, as and when the application is made for compensation appointment, that will be disposed of within a period of 6 months. I have annexed that judgment also. Had there been disposed of, my lord, then income of the incumbent, the petitioner, father or family members would not have been 90%. That is my submission. The inquiry was held on 2017, date of death 2013. The lapse of 4 years, all the incumbent has income from the family that has been calculated. And they have been calculated 2013. Within 6 months from the date of application, in terms of the order of the judgment of the Supreme Court, then the income would not have been 90%.
That was not controverted. Page 99.
87. ওটা 99 ওরা কি বলছে আমরা তো দিয়েছি কখন রিপ্লাইয়ের সঙ্গে
Page 74 calculation was not controverted before that.
Yes, not only that, he has withheld vital information. He has withheld vital information. The wife of the deceased is herself a government employee.
Yes.
She has furnished the income, he has withheld it from the court. And he is raising an issue why it was considered after 3 years and 4 years.
4 years not after the date of 2013.
You have to
Yes.
approach bona fide, not in this
Bona
way,
fide,
not by resorting to suppression of relevant and material fact.
if
Can you invoke the tribunal or writ court jurisdiction by
No, that
suppression?
certainly
Then
not.
where is the
But
question of
only question
where
is-
is the question of hearing anything else?
that the report has been furnished.
Where is the question of hearing anything else from such a person? You tell us. The law is very clear. You are seeking a benefit like compassionate appointment. And this is the way you are approaching the court.
The Supreme Court, your lordship knows that only the terminal
That
benefit.
for
that-
after withholding vital
terminal
information,
benefit can-
after withholding vital material, it should be discussed and decided.
I'm not-
We are on that, address on that, then go to anything else.
terminal benefit.
First tell us why we should hear you when you have suppressed material fact. First tell us why we should hear you. Then anything else you can be allowed to say. This is the way.
Submission, my lord, I have
You have stated in the OA. You have not given there. You have not given this court also. And you are making submissions as if they have committed a big sin. Look at your own conduct first. Then you look at their conduct. This is not the way. You know very well what the law is. You are making it impossible to ascertain the thing and you are trying to take a benefit from it.
question, my lord, benefit, my lord, I am relying. But your lordship, the terminal benefit, even terminal benefit.
Nothing will you will appeal here from.
That cannot be
Not at all.
that cannot be substituted.
You don't know.
For compassionate appointment.
We don't know.
That I have bought the judgment, my lord. Every judgment, everywhere, my lord.
Again, we are asking you whether you are entitled to be heard in view of suppression of a material and relevant fact. Tell us first, then you may go to any issue you want to. Tell us.
Your lordship, supplementary affidavit, if your lordship.
What supplementary at this stage? You have suppressed from the tribunal also. You have suppressed from the tribunal also. You have suppressed from this court also. Your mother herself has given the entire calculation. You say that there is no basis for calculation. You admit that the mother has given the calculation and you withhold it from the tribunal and the writ court. And you are raising issues as if they have committed a big sin.
But I'm not on that much. I
No,
cannot,
we are on that.
I cannot say, my lord, what I have done. But because I am holding the brief, that is my
Mr.
responsibility.
We are not telling you, Mr. So-and-so. We are talking about the applicant. When we say you, we don't mean you. We mean the applicant. We mean the writ petitioner. We are not saying about you. Just see how you have approached the court. Whenever we say you, we mean applicant. Whenever we say to him, we mean estate. We don't mean the advocate. We are not saying anything to you.
A mistake on the part of the.
No, it is conscious because he has stated in the OA that his mother gave a response and he has not annexed. Here also he has not annexed. So how it is a mistake? How can we take it as a mistake? We can't take it as a mistake.
You will also allow me to supplementary affidavit.
No,
because-
there's no
because
question. There's no
that
question.
document which was left out, my lord,
There is no question of doing it now.
I do not know whether inadvertently that has not been placed. I do
No
not know.
question of doing it now.
My submission, my lord, terminal benefit, even terminal, the calculation is made.
And where is the impugned order of 30th July 24? Page 71.
That was not a fresh application was made after this.
After this?
No, I'm showing at page 71.
Yes.
Prayer was made, my lord, for compassionate appointment.
No, prayer was made in 2013 itself.
2020. No,
13.
my lord is asking, my lord, at page 71,
Yes.
appointment on compassionate ground.
No. Prayer.
Yes, 71. That is the impugned order.
That's number.
No, that is not the impugned order.
17 May 2024, another application was.
No, there are two applications.
No, 51, your lordship says, page 51.
It's like a representation.
Page 51, first representation after the date of the father.
No, that is there. My lord has seen it. 52 is the mother.
51 we cannot understand.
Understand?
51 we cannot understand.
Oh, Bengal. Sorry. Yes.
I cannot understand. My brother can understand. I cannot understand.
52 is the consent of the mother. And here,
Without her consent, he will not get.
কোন কনসেন্ট আছে এখানে আমার বলেছি কি বলেছি আমি এখানে
Without her consent, can you get it?
no,
You cannot.
no objection.
That means consent. Whether you say consent or no objection, it
I
is
have
the
no
same.
objection. It got the job on compassionate ground.
Without her consent, can you get it?
my lord is absolutely.
You cannot.
Yes, but it is fact.
So what is wrong with the order? Let us see. What is wrong with the order? Total monthly income is more than 90%. You are not entitled. What is wrong?
90% if Miller, the calculation is made, Miller, 2013 and 2014, your lordship is that the submission pro forma was submitted on 2014. Calculation was
In-
not
in-
made.
Even if you go by the 2008,
Then that would not have been 90%.
no, but before 2013, it had become 90%. Before 2013, it had become 90%. We have already seen.
That is in August. That is in
কোথায়?
90% was in 14th of August 2008.
What is the date?
14th August 2008.
No, no, সেটা তো circular, that is
Sir, my lord is asking for sir. My lord, we have not controverted that calculation before the tribunal. Page 99.
Yes, 14th August 2008. It was raised from 80 to 90%. Long before then, to 90%.
That is not disputed, my lord.
Then what
That is
remains?
not disputed.
Then what? Then what?
My submission, my lord,
Yes, what is it?
calculation made on such and such date, 2013 or 14, that would have been, my lord, not less 90%. The how they have calculated, the chart they have been prepared.
Your mother has provided the income, so they have calculated. Yes, heard learned advocate for the writ petition.
Seven.
My lord, I appeal for the petitioner, my lord. This is the affidavit of service. Well, this matter relates to, my lord, doctors seeking NOC to participate in a selection process to be conducted by AIMS. My lord, your lordship heard one matter, my lord. Your lordship fixed the matter on this coming Tuesday. Tuesday week, this matter was fixed. My lord, in this case, my lord, the petitioner is seeking an NOC to participate in selection process for the post of assistant professor in pediatrics in AIMS. Now, my lord, he has applied before the authorities, my lord. Nothing is forthcoming. My lord, I moved the tribunal, my lord. Tribunal is not functioning. That compelled me to move before the lordship, my lord. My lord, the advertisement which is there, my lord, is at page, starts from page 37. And my lord, the NOC which is required is page 55.
Page 35.
Page 37 is the advertisement, my lord. And page 55 is the requirement of NOC. Now, 38, if your lordship turns, my lord, there are two posts of assistant professor. My lord, page 38, my lord, serial number 22, pediatrics. My lord, at the right hand side, my lord, your lordship will find assistant professor. There are two posts. I fulfill these criteria, my lord, and I was
Page 38.
38, my lord. This is the tabulation form given, my lord, the number of posts. Point 22, your lordship will find pediatrics.
Yes.
Now, my lord, the first is professor, additional professor, and the last column, my lord, your lordship will find assistant professors at the top.
One.
My lord, one is for the, my lord, OBC category, one is for
Yes, and one is for
EWS. Lordship has got it, my lord.
Yes.
So, my lord, I fall under that category, my lord, OBC, and on in case of EWS, my lord, it said, my lord, if none is there, then, my lord, it can be, my lord, converted to any UR category.
When did you apply for the NOC?
My lord, after, my lord, I have applied for the NOC, is that page, my lord, my lord, page 72. Page, I have applied, my lord, 3/12/2025. Lordship will find at the top, memo number has been given, my lord. I have applied on 29th, my lord. It was memoed on 3/12 and, my lord, received by the health department on 4/12. The next page, your lordship will find the seals are there, my lord. Stamp and seals are there. I will just comment on it.
So it has not been rejected.
My lord, nothing has happened, my lord. My lord, I'm being told, my lord, first week of January, my lord, things would be over. So if I do not get the NOC with a specific, your lordship has seen in earlier matter, also in this
Where
matter.
have you, from where do you get it that in the first week of January it is?
No, my lord, it's not been mentioned, my lord. Your lordship will find a timeline has been given in the advertisement itself.
Yes.
My lord, your lordship kindly takes up page 55, it's the NOC part. And my lord, I'm coming with the timelines, my lord. I'm going to look at it. Mark করেছিলাম কোথায় গেল টাইমলাইনটা কোথায় গেল মার্ক করা ছিল আমার ওই পিটিশনে মার্ক করা ছিল এই পিটিশনে ওই পিটিশনটা মার্ক করুন ও নেই সোমনাথ পার্ক এখানে নেই বাড়িতে নিয়ে চলে যেতে
The time of interview, not
At the time of interview, you have to produce. My lord, your lordship takes up, my lord, page 51. My lord, this is a timeline has been given. My lord, the application process, the online applications will be made available on AIMS Kolani official website, i.e. such and such. The link for submission of online application in respect of the above said post along with the relevant information will be activated on the date of advertisement on the employment news, Rozgar Samachar, or earlier as posted on the website. First cutoff date will be published on the institute website. My lord, second cutoff date will be published on the institute website. Third cutoff date will be published institute website. Last date of online application, my lord, it says, my lord, if your lordship takes up the very first part, my lord, from the 1 month from the date of advertisement, as a cutoff date as published in the institute. Right? And the last date of receipt, the hard copies of online application duly signed, along with the self-attested copy of the relevant documents, as per terms and conditions of advertisement, 10 days from the last date of receipt of online application. Now, my lord, if your lordship takes up,
So cutoff has not been prescribed yet.
exact date has been not been prescribed. It has to be. It will be there in the internet, my lord. Then I will have really short time to, my lord, do anything.
No, then you will get at least 10 days.
Yes, my lord. 10 days, my lord. I have to move the tribunal and get an order, my lord. Your lordship.
No, we are not talking about tribunal here.
Yes, my lord. Yes, my lord. 10 days I will get that time, my lord. Maximum I will get 10 days time.
After it is uploaded,
Uploaded.
after the date is uploaded. Plus, this advertisement of 2810.
Yes, my lord.
Where were you till December?
Now, my lord, I have already applied
In December.
Yes, my lord.
After 1.5 months, you have made an application for NOC. Just be your own conduct.
My lord, just, my lord, I mean, told, my lord,
Your date of application.
advertisement date. It's on 2810, my lord. My lord. The advertisement clearly speaks of 2810.
Your application date.
My lord, 312.
Then
My lord, I initially applied, my lord, for the post, my lord, online, and thereafter I required.
well, more than one month later, you have applied for NOC.
My lord,
For urgency. It is not that you have applied within a week and you are waiting. Just now you have applied. Immediately after applying, you have come in. Where is your application? Which page?
my lord, page 72. My lord, I applied on, my lord, your lordship will find the date has been given on 29/11 after 1 month. And my lord, no. Your lordship will, no, my lord, your lordship takes up the next very first page. It was memoed by the concerned my lord, college where I am in at 3rd December. My lord, next page, your lordship will find the department received on 4th December.
Correct. So therefore we are saying no urgency on your part also.
Next the memo. But it's kept pending with them, my lord, even in the department from my lord 412.
This is what we are saying.
Yes, my lord.
It's hardly been there with them for 2 weeks. 2 weeks. You have given an undertaking that you will resign.
As the NOC says, my lord, the NOC clearly speaks, my lord, if NOC would be given with a precondition that if I am selected, my lord, I have to tender resignation. If your lordship sees the NOC once, page, my lord, that is at page, my lord, NOC part, my lord, page 55.
No, in your application, have you said?
Yes, my lord, I have said, my lord, at last paragraph, page 72, I also undertake that in the event my selection in the applied post of assistant professor in Department of Pediatrics at AIMS Kolani, I will tender my resignation and will never claim in the benefits of my past service under the government of West Bengal except GPF and GIS, GI, and it should be S and it's a IS should have been, as per rules. GIIS.
Yes, you file a report by 6th January.
Item number 8.
Yes.
In this matter, I am appearing for the petitioner. On the last occasion, the learned counsel appeared for the state respondents, took time for kindly see the last order.
25th November, there is no cabinet meeting till today. Normally, meeting is held once in a month. Till date, because
That day you said that it was likely to be held.
but because of some disturbance in Calcutta, this was adjourned, likely to be. Can you fix any date after vacation? Any date, we are not expecting.
The first order was passed on 16 June 2023. There is a direction upon the chief secretary to hear out the issue and decide. Then they formed a committee.
After recommendation. Now just only getting approval from the cabinet, it will be notified.
More than 2 years has been elapsed.
Yes, we are aware. As prayed by the learned AGP.
Item number 9.
Lordship, item number 9, I am for the appellant, Lordship. In the last occasion, Lordship, the matter got dismissed for default, Lordship, and restoration application has been filed. The matter got dismissed on 10th of May 2023, Lordship. The then advocate on record subsequently was depaneled, and as a result, the matter suffered. Lordship, the restoration has been filed, Lordship. First, I'm praying for restoration of the application. There has been a delay to file the restoration application of 100 days. Delay of 100 days there.
What is the order passed by the tribunal?
The order was passed by the tribunal on 22nd of May
What is the
2023.
order passed? What is the order?
Order, Lordship, there has been allegations against the respondent number 1 in regard to, Lordship, there are certain properties which has not been disclosed. Subsequently, names of respondent number 1 and another respondent has been recommended by the department, which PSC has recommended the other respondent and has rejected the respondent number 1. Accordingly, the respondent number 1 has not received the promotional post, which according to him should be given to him. So there has been a direction to give a retrospective effect and give an appointment to the respondent number 1. Now here a situation has arisen. Here, Lordship, two situation has arisen. First, that respondent number 1 has already retired in 2024 May, sometimes in May or February 2024. And second situation is that we have recommended, the appellant herein has already recommended the name of the respondent number 1. It was upon the PSC to select whether respondent number 1 is the suitable candidate or not. But PSC has not been made a party to the OA application. So the direction has come upon the department and not on PSC, who has actually selected the respondent number 2. No.
Takes up page 17. This is the cost cycle of the original application. PSC was party. Because, sir, it's not that some MSA my learned friend is not aware of the facts. If the Lordship takes up page 17, this is the cost cycle of the original application.
What is the day on which it became due to you?
my lord, the day, my lord, on 13th of the day when the promotion was given to the, my lord, the respondent number 3 herein, and my lord, the private respondent number 4 before the learned tribunal.
He is your junior.
He is my junior, my lord.
When was it given to you?
Not, I'm just saying, my lord. The date was given, my lord. My lord, 13th of March
13th of March
2019.
2019. And his charge sheet was given on 2nd of April 2019.
So according to you, you are not to issue the promotion order.
Lordship, I can show the documents. We have made the recommendation. If
Is that-
Lordship kindly comes to uh, just a moment, Lordship. Page number 49, once 49 of the petition, Lordship. This is the proposal for the post of Chief Probation cum Aftercare Officer. And if Lordship subsequently comes to page number 52, there were two candidates. The name first is the respondent number 1. We have recommended the name of respondent number 1.
So where is the order turning down the benefit?
Yes, Lordship, I'll just come to that. Lordship, the order for turning down penal action was this. Just a moment. Lordship kindly comes to page number 74. No, pardon me, Lordship. This is the yes, Lordship, page number 60. '59 and 60.
'60 is not an order rejecting his plea.
60 is not an order, but page number 59. And competent authority passed the order on 1st of June 2019. That is at page 75, Lordship. Page 75.
Why have you assailed the order of respondent number 5? Respondent number 4?
Tribunal's order, Your Lordship.
No, why did you assail the promotion of respondent number 4?
In the tribunal, my lord, the state was a party, the principal secretary was a party, third is PS.
Why did you assail the promotion of respondent?
Yes, ma'am. Well, respondent number 4, the private respondent therein was given the promotion, my lord, superseding me. My lord, the tribunal, my lord, came to a conclusion after, my lord, going through the judgment of Union of India, Alok Kumar Sarkar, which says, my lord, after going through my lord, KV Janaki Raman, well, I had to have the judgment with me. My lord, it says, well, in that case, 4 criminal cases were lodged against the incumbent and 4 departmental proceeding was initiated. But the Honorable Court said, the day when DPC was there, my lord, initially it was made in seal cover. He approached the tribunal, my lord, rejected his prayer. He went to the High Court. The High Court said, my lord, the day when the DPC took place and the promotions were given.
So date of issuance of charge memo is the relevant date. Prior to that, any date, it cannot be, you cannot be deprived.
Absolutely.
Even if it is in contemplation, you cannot be deprived. This law is clear based on KV Janaki Raman's case.
Yes, absolutely.
Only from the date of issuance of charge memo. So the date according to you for promotion to the other person was prior to the charge memo. So you are claiming from that date.
Exactly.
But now it is immaterial whether he gets the promotion or not. You can only get the notional benefits.
Yes, seeking the notional. As of now, my lord, I'm been retired. He has also retired.
But that
I
is a
may be
fresh
getting-
cause of action, Lordship. Here to Lordship, the
But when I-
direction was.
In whether it is fresh or it has become, it is a subsequent event for which he need not move separately. We'll see that. How it is a fresh cause of action? It is something which has happened during currency of the proceeding. When he came to the court, he was very much in service. How it is a subsequent event? Why have you challenged the order if you have given a recommendation and we are not able to see?
Because subsequently it has been proved that he has not, in our show cause, there have been certain allegations that
Where is your rejection order? Again and again we are asking you, when have you turned down his request? What is the reason for not giving him the promotion?
Lordship, we have not given a promotion. It's not our case. Our case is that we have recommended, the promotion has not been given by the PSC.
Where is this? Show us, where is this averment? That we have nothing to do with the promotion, we have given the recommendation, but PSC has not implemented.
Yes, Lordship. If Lordship kindly comes to page number 5, Lordship. So, page 5,
Of?
paragraph, page 5 of our application. Lordship.
No, show us from the OA.
OA.
Yes. Or you must have filed a reply in the tribunal. Show us from your reply.
Just a moment.
You find it, we'll restore and we'll hear it in January. The
Item number 12.
12 by appeal.
This is for report.
Something urgent.
Your Lordship has heard this, Madam, my lord, regarding their compassionate appointment. The mother has given the proposal for the compassionate appointment of the.
The other side of the.
My lord, your Lordship has already decided the issue. The judgment passed by your Lordship. I have handed over.
We understand what you have to.
जा कब से वेट कर रहे हैं.
The other side. Give a date in the second week. We take it up. Second week is all right.
हाँ, I have no problem.
12th January.
12th January.
No, 12th January is a holiday.
Oh, 13th.
But they have some idea.
13th January.
13th.
But add to that, just after the vacation.
Then we only have 5th and 6th. These WPST matters are being taken up on Monday, Tuesday. We have allotted separate dates for everything.
Yes, I know.
Otherwise,
The hearing is almost done. 99% done.
we'll see.
Item number 13.
Yes, Lordship. Item 13, Lordship, I am appearing for the petitioner. Lordship, this is my affidavit in reply. Copy has already been served upon my learned friend, Lordship. Lordship, 6-0 is the Lordship rejection order. Matter relates to compassionate appointment. Lordship, it is rejected on the ground that 2 years and 8 months delay. But it is not the fact. Lordship, I have filed my application initially within 2 months. My Lordship father died on 12/3/2016. Lordship, page 37. The PT applicant himself along with his mother, Lordship, applied on 12/5/2016. And Lordship, within 2 months. Thereafter, Lordship, the authority, Lordship, on 10/11/2016, page number 39, Lordship, Lordship, on communication received by me that the pro forma application was, Lordship, incomplete. And also, Lordship, asking certain documents. And main point is this: the death benefit, all relevant documents, including last pay certificate. Lordship, for disbursement of death benefit, it is take some time because Lordship, petitioners, Lordship, mother was residing at state of Bihar at Bhojpur district. So it is take some time. 2016 date of death, 2017 it.
Consider after the.
Yes, Lordship. So they have received within time, within 2 months.
Consider after the.
Yes, Lordship. After that.
The affidavit in reply.
Oh, nice.
Item number 14.
Service upon the 6 and 7 does not. Service upon the 6 and 7 is not satisfactory. So kindly praying for time and press.
Only for 6 and 7.
We are informed that service.
Item number 15.
I am praying one time for fighting. Immediately no.
Opposition has been served.
Is my
Today it is being filed.
the voice.
Already. For filing a reply.
Item number 16.
None appears for the writ petitioner.
উনিশ 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 দাও উনিশে ফাঁকা আছে। উনিশ উনিশ
Item number 17.
Same order.
Same order. উনিশ 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 এক
Item number 18.
বাড়ি চলে যাও।
You need to file opposition. None appears on the.
উনিশ এক
Item number 19.
We need to file reply in response to their opposition. We need some more time, Your Lordship.
Petition has been served.
Yes, Your Lordship.
Has paid
পেরেন্টস দিয়েছে
19 এর appearance.
পেরেন্টস
তাহলে order এরকমই হবে।
Item number 20.
20 my lord, I am appealing on behalf of the petition. Direction for filing supplementary affidavit in respect of FIR complaint. Annexing FIR and last order.
Item number 21.
My lord, the item number 21. For a short pass.
Today again, prayer is made for.
Item number 22.
22, my lord, I am appealing for the petition. In earlier occasion, your lordship directed to file compilation, my lord, annexing all the notifications that were issued time to time by the state of West Bengal. That direction has been given to my learned friend.
Here we have got a copy.
Yes, ma'am.
We'll fix it for hearing after the order. The compilation.
That, ma'am.
Go through it. Go
Yes.
through it.
Item number 23.
My lord, item number 23, I am for the petitioner, my lord. On the last occasion, my lord, your lordship, on the last occasion, your lordship directed the respondents to file an affidavit. Since I have already joined the transfer post, your lordship was of the opinion, let them file an.
When can you do it? We are informed by the learned.
Item number 24.
Opposition, I am filing. Hand over for 1-2 days. Love together.
Affidavit in opposition.
Item number 25.
For the petitioner lordship, the matter lead by Mr. Shobhasari Chatterjee. He's on his leg on court number 1, lordship. Kindly make it not today, lordship.
Has spread.
Item number 26.
And in 26, there was a direction on the state respondents to file an affidavit to indicate what is the memo regarding the delayed disbursal of the retirement benefits. That we are saying the affidavit has to be vetted. If some time is granted to us, we can come back to the
Learned state count.
Item number 27.
27, my lord, there is a direction to file affidavit. In 27 and 28 are the more or less identical matters. But 27, they have not used any affidavit, my lord, or 26 is the main matter. In 28, my lord, they have used one affidavit.
Filing opposition.
In 28, my lord, they have served me one opposition, but main matter is 27.
In 27, you are not filed.
No, my lord.
Who is appearing in 27 is 174.
27 is 174.
And 28.
Not today. Both matters not today. State House is not here, otherwise we could have.
Opposition we kept in record.
On 28.
28, my lord, they have filed, my lord.
28 may record an order. The affidavit in opposition.
Item number 29.
Lordship, this is my application. Lordship, pursuant to Lordship's leave, I am filing the supplementary affidavit copy.
Lordship, the representation was, one page was missing with the original petition. That is why Lordship granted us liberty to file the representation presented here today.
Supplementary application.
Item number 30.
Lordship, I am appearing on behalf of the petition. I am praying for only not this can be taken me after vacation. Lordship, can you take?
Jointly pray this. Yeah.
20.
20 না 30 30
না 3 তারিখে আসবে হ্যাঁ
ಹೌದಾ ಅಮ್ಮಟ್ಟ
Item number 31.
Petitioner, my lord. I am here challenging the order. Order passed on 16th May 2025, my lord. Last annexure, my lord. Our contention is that, my lord, the order passed in this by the learned tribunal is not maintainable on the ground that the second departmental proceeding initiated against the petitioner is barred by res judicata.
Barred by res judicata.
Res judicata, my lord, because on same charge, first proceeding was initiated and it was withdrawn by the state respondents. Without giving any liberty by the tribunal, second proceeding on same charge was initiated by the state respondents.
It was withdrawn or you were exonerated?
No, my lord. On the first proceeding, they gone up to issuing show cause notice to me on the ground that my lord, kindly come to.
We'll consider this. We are adjourning it for the day. We have a matter fixed at one. Not today.
My lord, kindly come. Kindly take up the matter next week, my lord. I have some difficulty.
Not today means Monday.
Monday.
এটা কি অর্ডার পাস হয়েছে
This will come on Wednesday. Oh, it can. You don't want it this week,
Oh, my lord.
as paid by the Petitioners Council. Listen. We expect such mentionings to be made at the time of rising. We expect such mentioning. Please, please. Yes. All 1 PM matter.
Item number
We have a
61.
matter fixed for 1 PM.
My lord,
Yes.
I'm for the appeal.
Who is for the other side?
I have indicated, Lord, I have served notice upon Mr. Jana of 61. You are there? Well, I'll finish it, Well, before opening the brief, Lord, may I just, before one in Lord, neither the memo nor the stay have happily drafted, Lord, the writ petition have not been annexed. Lord, may I hand over the copy of the writ petitions? Well, may I hand over the copy of the writ petitions?
What is the order?
My Lord. My Lord, kindly come to page 47 of the stay application.
Notice has been served, I have not been served any application for stay or prolongation of demand. No copy has been served.
All right.
Only notice has been served to.
You have said so. We have understood. You need not repeat the same thing.
Yes. Page 47.
Matt.
Yes.
My Lord.
Give him a copy.
I will, my Lord. My Lord, on the difficulty is this, my Lord. I am on the threat of compliance, my Lord.
What is the date fixed today for?
Today is the date for compliance, 2 p.m.
What does the Honorable Single Judge want? A report?
No, the compliance, because the direction of your lordship has seen, the direction was for implementation of the health scheme. We have not, because we cannot, my Lord.
Health scheme.
My Lord, we cannot. As because these are the policy decision and the facts recorded in the para 4 of the impugned order, my Lord, the totally, my Lord, wrong statement has been made from the bar.
November 2020,
My Lord.
January 20.
My Lord, it is noticed that 2 other institutions who are
What is independent health scheme?
My Lord, independent health scheme, my Lord, they will be able to get several benefits under these schemes. The persons who are the respondents or the petitioners before lordships, some of them out of 25, 18 are non-teaching staffs. They are not entitled to get the health scheme. And
We are asking what is the independent health scheme. We are not asking whether they are entitled or not. What is the independent health scheme?
Health scheme, my Lord.
Yes.
My Lord, one second. My Lord, the cashless treatment benefit in government hospitals.
So that is not given to government employees.
That is given to the government employees. The petitioner before the writ petitioner are not the government employees. They are employees of the sponsored institutions. They are claiming parity with the government employees.
And the Honorable Single Judge has directed to extend the parity.
My Lord. And the contention recorded in para 4, Lord, that is totally contrary to the facts. Lord, moreover, Lord, we are not given any opportunity of opposition, Lord, so that we cannot bring on record the fact that these are not given to this
Order was passed without any opposition being filed.
My Lord. Without any opposition.
Have you stated that no opportunity was granted for filing an opposition?
In the opening, I stated, my Lord, these are not happily drafted, my Lord, but my learned friend was there. They can apprise your lordship that no opportunity of opposition reply was there, my Lord.
So why do you wait till the contempt is reaches this position to come to the court?
My Lord, I will going to get it.
Why do you wait for the matter to become so urgent before you approach the appellate court?
My Lord, in the meantime, there were other advocates who are now not in the panel, my Lord. That was a difficulty in midst, Lord. The advocates who preferred the applications, they are not in the panel. Some of them have left the panel, some of are not coming to the court, my lord. That's why
When
I
did you file the appeal?
Lord, appeal has been 16th September, my lord.
And there is no limitation.
There is 356 days delay.
Where is that application?
My lord, can your lordship can find, my lord? I have filed the can 1, my lord, of 2025. The 56 days delay, my lord.
You have served a copy.
I will, my lord, I will. But kindly grant me liberty to pray for adjournment before the contempt court, my lord. Otherwise, my lord, I will be in difficulty.
Why you have come after such a long time?
My lord,
You comply it.
my lord, I cannot, my lord.
You can comply it subject to result. Why not? Who is stopping you?
But they are not eligible.
We don't know. You may be ultimately right. But if you come in such a lackadaisical manner, you should comply subject to result of the appeal.
Well, may I pray for one thing, my lord?
Yes.
Well, kindly fix any day this, my lord, next week, my lord.
Impossible. Can't
There is a short point involved, my lord.
possible. Can't be.
Well, I will be. My appeal
Cannot
will-
be, sir.
Well, my appeal will be in fact.
Because you are very lethargic. Therefore, we can't do this.
Well, it's my
For
fault,
your
my
inaction, you cannot claim a premium.
lord. No, my lord. Definitely not, but
Then
on
that
my
ends the
fault,
matter.
the
Then
client
that ends
must
the
not-
matter.
Well, on my fault, my client must not suffer, my lord.
Then we don't know.
Well, kindly.
Then
give
we
that-
don't know who is to face the consequence.
Well, kindly give me that much of liberty, but next week, any day, my lord, as per lordship's
While you
convenience.
complied subject to result of the case, who is stopping you?
My lord, that is not possible. That is a policy decision we have taken, lord.
Why this delay, sir? Have you seen the judgment of the apex court
I have.
last week?
2025.
What the apex court has said
Day-to-day
for government
explanation.
appeals. His Lordship Justice Padiwala's judgment.
I have,
You
I
have
have.
seen it.
I have, my lord.
So, tell us.
I have seen.
Then, what can be done? You are not even served the application on them. What can be done? You pray for adjournment before the single judge. You can pray for an adjournment before the.
But kindly can we that liberty, my lord, from praying adjournment on the next
You-
statement?
we-
Kindly
We are
that
not.
much of liberty.
We are not stopping you.
No, Lord, unless your lordship grant us that liberty, my lord, I have to face the consequences. My appeal will become infructuous.
But look at who is responsible for your this situation.
But the advocates lacuna is there, my lord. I must say, my lord, advocates lacuna is there. My lord. For that, my lord, the clients will be the ultimate sufferer. The state exchequers will be the ultimate sufferer.
Notice was served in January 2024. Then contempt notice was served in June 2025. Then another reminder.
You have filed contempt in June 25,
24.
24.
24 order was communicated January 2024
When you have filed the contempt application.
and contempt order application 2024.
Then where were you?
Nothing after the direction of the court contempt copy was served. Then they have come with it back without any explanation.
How many days of delay?
356 days. my lord.
We'll have to consider.
But explanations are there, my lord.
Learned friend said that the affidavit in form of report in form of affidavit.
No, opposition was not there. And my learned friend, without going to the record, is saying that there is no explanation in the section 5, my lord. That is very ridiculous, my lord. I must say.
No, he is saying
He
that.
says that in the section 5, there is no explanation.
No, he is saying that there was a report in the form of affidavit before the single judge.
No opposition was we filed, my lord.
We don't know, but at least I am seeing here that report is being filed in many cases. This is a practice which I have seen here. It is being followed in every court.
No, my lord,
So it's
there
nothing
are
new for you.
There is avenue of opposition and
In
reply.
many cases, the state council themselves said that instead of opposition, let us file a report. What can we do?
Well, taking name of a particular advocate, well, perhaps not. It is not proper.
That is between you two.
Perhaps not proper. It's
That is
taking
between both
name
of
of particular and your advocate. And,
We don't want
Letting
to.
him-
We don't want to comment on this submission. We don't know what to say.
order says that someone appears for the state.
It's for him to understand these things. We can't do anything.
Lord, only, my lord, kindly that in much indulgence, my lord. One indulgence, my lord, praying.
You pray for adjournment.
But kindly give that much of liberty only, my lord. And fix any date as per
2 p.m. fixed matter, item number 10.
My lord, this matter has been fixed for today, my lord, for giving interim protection. My lord, on Monday, my lord, my learned senior friend filed one affidavit. My lord, this being the
Yes, he was saying he is going to file some.
yes, my lord, third affidavit is been used. My lord, in their affidavit, my lord, what I get, my lord, they have rather clarified, my lord, my stand. I may say, my lord, subject to kind leave and consideration. But if your lordship takes up their last affidavit, my lord, which was filed by them, my lord, on the date of August, most likely day before yesterday, my lord, it has been found. 15th, my lord. My lord, your lordship kindly takes up, my lord. I may be not showing all the paragraphs, my lord. Your lordship kindly takes up page 22, paragraph 18. Page 22, paragraph 18. Now I'm reading, my lord. In Kolkata police, there are two types of forces. The armed branch being the combat force and the unarmed branch being the non-combat force. The duties of armed sub-inspector and surgeon in Kolkata police are noticeably different from those of the unarmed sub-inspector. Unarmed sub-inspectors carry out general policing, investigation and submission of the charge sheet before the honorable courts. The armed sub-inspector, however, are deployed in a major law and order situation, crowd control, guarding vital installation, anti-terror operations, providing armed protection in event of too intense for unarmed personnel. They also act as an armed reserve force during crisis, escort arms, ammunition, and the government treasuries, and take part in anti-extremist operations such as cordon and search, ambush.
That will come later. Actually, see, we were also going through the file. What we have seen is earlier they have filed an affidavit. This is the date of that.
The first affidavit they have said, as because I have participated, I cannot. Thereafter, later on, they came to know that is not my participation, somebody else's name is same. Your lordship allowed them to withdraw it. Second affidavit, they can say, my lord, as because the matter is pending before the Supreme Court, no interim order should be granted. Now, my lord, when your lordship was keen to pass the interim order on the last occasion, my lord, my learned senior friend asked for this affidavit.
So one stage has already been crossed.
My lord, two stages have been crossed. My lord, one being, my lord, the preliminary examination. Second is, my lord, the PET and PMT. Now, my lord, third stage is there. That is proper final written examination. And fourth would be interview. My lord, if some candidates cross the, my lord, first two levels, then the third level of, my lord, written examination, which is of 100 marks, my lord, 85 marks or something, that will be taken into consideration for final selection. And my lord, it says, my lord, the first two examinations marks won't be tagged. Only the written examination and the interview marks will be tagged for final selection of a candidate. So, my lord, even if, my lord, somebody has crossed the level to the second to third round, my lord, unless he clears the third round and the fourth round, my lord, he will not be selected. So, my lord, in all essence, although, my lord, I may say selection is on, but in all essence, my lord, as because these now, my lord, we are the verge of that area, my lord, when, my lord, the marks would be taken into consideration for my final selection, for any of the candidates' final selection. That is not been done, my lord, and it's going to be held on 30th of December. That is the reason your lordship has fixed this matter today. Now, my lord, in their affidavit also, if this last very affidavit, well, if your lordship takes up, my lord, they have given a stereotype of woman, why the woman cannot be, my lord, or the woman candidate cannot be allowed in, my lord. Initially, it was, my lord, an armed branch, my lord, they themselves has clarified, my lord, sub-inspector unarmed branch is also different. But if your lordship takes up page 23 once,
23 of this affidavit.
this last affidavit, my lord, I don't know the date, date has not been given. Advance copy has been served, my lord, I accept that. Well, page 23. Now, my lord, your lordship takes up the second paragraph.
This is of 1512.
Yes, 1512. My lord, page
Let us read it. Just give us.
Yes, my lord.
Most historically, only mounted police in India is only in Calcutta after independence.
December 15th. Yeah, yeah. Yes. But what they have projected in the affidavit, my lord, this is my understanding, my lord. They mean to say, my lord, the women are basically weaker section of the society and they cannot be doing this job of what the armed police, armed sub-inspectors or unarmed. Even, my lord, they have segregated unarmed also. My lord, they have stated, my lord, with regard to the women, the unarmed sub-inspectors of police, they are more likely to do the, my lord, basically the investigating agency would do, my lord, the investigation of 498 days and all, my lord, those were related to women. Well, this what they have said. Now, this very attitude of sex stereotype of women has been deprecated by the Supreme Court way back in 2008 in Anuj Garg. My lord, thereafter it followed in Babita Punia, all other judgments, my lord. This, my lord, giving these women candidates, my lord, as they are not physically fit or they won't be, my lord, according to their assumption. My lord, that is the reason those judgments were there. My lord, even in Anuj Garg in 2008, the Honorable Court said, my lord, that if such situation arises, it's a duty incumbent upon the state to ensure the safety of the woman, so that, my lord, somebody should not be excluded from, my lord, doing a public service. Now, if your lordship allows me, I can place those judgments, my lord, one by one. Well, all along the Supreme Court, my lord, deprecated this attitude of the authorities by which, my lord, women have been stereotyped as, my lord, a weaker section of the society, and they cannot do anything, my lord, which a male can do per se in terms of logic. My lord, your lordship will find in Babita Punia, my lord, there's reference of Lieutenant Colonel Sophia Qureshi and all others, my lord, references are also given. My lord, we have also seen that very lady, my lord, during this Operation Sindur part. But if they can do the combat part, my lord, what prevented the police authorities, who is per se may not be that combatant in comparison to the Indian military or Indian Air Force or, my lord, Indian Navy, my lord, where the women are being allowed. And, my lord, in this case, my lord, such a big thing is happening in Kolkata police that I've been segregated. My lord, this segregation on basis of my lord, this thinking of the authorities that women are weaker section, they cannot do anything. My lord, that hurts, or, my lord, I mean, say, my lord, that very, my lord, thinking, my lord, hits the core of Article 14 of the Constitution of India and 16, my lord. My lord, this cannot be. I cannot be differentiated in this fashion when the Honorable Court has said something different, my lord, in 2008 in Anuj Garg, in 2020 in Babita Punia, and in 2021. Well, this is a consistent view of the Honorable Court, my lord, that this cannot be done. But still, my lord, we are facing this situation, and, my lord, this affidavit comes out.
2008 judgment was regarding that
Consumption of liquor, my lord.
liquor service in that area where liquor is being served.
My lord, where there's, my lord, it's 25 years, male below 25 years were excluded, and any woman. My lord, the Honorable Court said state should take the, my lord, responsibility to ensure, my lord, this thing doesn't happen, whatever the state's apprehension was. My lord, it is also, my lord, if your lordship allows me, there also, my lord, these points were taken by the union, my lord, or NCT, my lord, government of Delhi, my lord, that this will be the proposition that the lady, my lord, employees may face where alcohol is served. My lord, the honorable court said, my lord, this cannot be the proposition. Even if that assumes, my lord, the state has the responsibility to ensure that nothing happens. My lord, what they have said in a case, my lord, if your lordship takes up, my lord, what they have said, my lord, in the affidavit, we are at page. My lord, I'm page 20.
But you are showing 22, 23.
23, my lord, page 23, my lord, your lordship is the state government's policy of excluding women from only 3 posts. Now, my lord, initially I was confined to, my lord, only the armed branch. My lord, they now say, my lord, even the sub-inspector unarmed branch is different. I cannot be there. My lord, this is their stand, my lord. As because, my lord, your lordship will find page 23.
No, whatever is there, it is there in the advertisement. They cannot add to that by the
My lord, that is they have said, my lord. Your lordship, kindly come page 23 once.
Page
23, second paragraph. My lord, state government policy of excluding women only 3 posts. My lord, now they have said sub-inspector armed branch, my lord, which is there in the advertisement, I cannot be there. Sub-inspector unarmed branch and surgeon is based on the view that the armed roles demand a higher level of physical strength and stamina, which women on average may find more challenging. In certain situations, women may also face increased risk in a male-dominated, high-violence environments, making them more vulnerable to harassment and physical harm. This raises the safety concern of both of them, and for others, they have expected to protect. Malad, this very point was also taken by the union in the Malad Babita Punia case. Exactly this point. Malad, professional Malad hazards that the combat forces will face in combat situation. This very point was taken by the union. That was also deprecated by that.
Sub-inspector unarmed branch is available.
Yes, my lord.
But a sub-inspector is there. Ready sub-inspectors are there. It's called sub-inspectors, 34 posts.
Right. In the affidavit, they have said, my lord.
No, where is the advertisement?
Advertisement is at page, my lord, page 30 of the writ petition. Unarmed branches have, my lord, they have segregated 2. One is with the male, another is with the sub-inspectresses are for the females.
That is under Article 15(3).
Yes, the vacancies are segregated.
Yes, my lord. Now in the affidavit, they have said, my lord, the armed branch, the unarmed branch.
Is 2 posts, only 2 posts.
My lord, that is a commissioner of police making an affidavit, my lord, this is the third affidavit. But I have to go by the words of the commissioner, my lord.
So you come to the advertisement.
Yes, my lord. Advertisement says, my lord, sub-inspector and sub-inspectresses.
Yes, the posts are separate.
Yes, the posts are separate. They have said. And my lord, but in the affidavit, they have said they have to do many other things. My lord, this is in the affidavit, my lord.
How it is.
My lord,
by the commissioner of police.
Yes, is affirmed by the commissioner. The first page says I, Manoj Barma. He is the commissioner of police, my lord. Manoj Kumar Barma, son of Hajarilal Barma, working for gain as Kolkata Police. First paragraph that I am working as commissioner of police, Kolkata.
Where is that statement?
My lord, page 2, paragraph 1.
No, where is that statement regarding?
My lord, that statement at page 23, my lord. If your lordship takes up page 23 once. Page 23. And they have mentioned 3 posts, and thereafter they mentioned the post. Had that been typographically, I can understand that would have been armed branch and my lord surgeon. My lord, they mentioned 3 posts. This cannot be a deliberate mistake or my lord, unintentional mistake of 3 or 2.
Where do they give the number of posts? Only 3 posts.
Yes, 3 is there. Now, my lord, from there, my lord, what they say on the armed polices will be do all other things. The unarmed polices, we will also do all other things. My lord, but we are vulnerable, and that is the reason we cannot be deployed. Even, my lord, your lordship will find page 8, paragraph 7, my lord, again they have said Surgeon and Sub-Inspector arm branch are more rigorous. Not on that, no. 17, page 17.
See, paragraph 18, perhaps.
Paragraph 18. Kolkata police, there are two types. Here they mention two types. But in the body they mention three types, and thereafter they mark, my lord, names. But the posts are given. Had that been, my lord, a typographical error, that should have been confined to armed surgeon.
No, but he's saying it appears to be an error.
My lord, error could be at one place, my lord. How the error
But when they are themselves claiming an error, how we can read
Let
it?
that be, my lord. I'm not on that.
We can't force that on.
Yes, my lord. But what I got, my lord, I have just laid out, my lord. And my contention is this, my lord, this segregating women on basis of
Yes. Yes.
my lord, this segregating on basis of this sex stereotype, my lord, I can place my judgments, my lord. It has been deprecated by the Supreme Court time and again. So this has been the situation, my lord. And my lord, as the examination of the final phase, for which the marks will be taken into consideration for the final selection, my lord, I will be seeking.
You are repeatedly saying final, but two stages have crossed.
My lord, in the advertisement they have said, my lord.
Two stages have already crossed.
Yes, that's true, my lord. Two stages have been crossed. My lord, that is, my lord, when I moved.
And how many more stages are left?
But two more stages. Two more stages are there, my lord, that is from the advertisement itself. And my lord, your lordship will find, had that been state been, my lord, subject to kindly, my lord, had the state, my lord, has made an affidavit stated before this honorable court that as because OBC is going on, we are doing nothing. Now, my lord, takes a volte-face stand. And my lord, one fine morning, the orders are there, my lord, they start recruiting. My lord, on affidavit, they have stated, my lord, we are holding our hands in one hand. Once the order passed, my lord, they could have come before lordship saying that this has happened, my lord, lordship grants us leave. They have not done so, my lord. So, my lord, the decision taken to continue with the further.
No, but thereafter matter was listed twice for this purpose.
Yes, my lord, that's true, my lord. This been listed twice, and
both the occasions no interim order was passed.
My lord, both the occasions, my lord, the first stage, my lord, my learned senior friend took the plea whether I can move a original application before the tribunal and come before lordship, or I should have been moving a public interest litigation, saying, my lord,
The issue does require consideration.
Yes, but I will be visiting this, my lord, at this stage, my lord, as because I can made out, I submit to kindly, my lord, I have made out some case, my lord, let there be interim order not to proceed with the examination. Your lordship may take about any day, first week of January, my lord, lordship may dispose it off, let the examination take place. If your lordship holds that I don't have a case, my lord, they may proceed. If your lordship holds, yes, I do have made a case, my lord, at least I will be saved.
Yes.
In Calcutta police, two types of combat force and non-combatants. But at combat force, certain qualification has been mentioned.
Everything is required to be seen.
Sure.
Whether this classification which you are trying to do
Yes.
is sustainable on the touchstone of Article 14, 16, 15.
Yes.
What is the inherent duties? What are the issues? Whether it can be sustained, whether it is proportionate or not. In Anusgar, the apex court has said a strict scrutiny is required to see whether, if such a classification is done, whether it is proportionate or beyond proportion.
Yes.
This is to be examined, but you are proceeding with the recruitment process.
Yes, proceeding the recruitment because
if ultimately she succeeds, then
but Kali consider when a writ petition is not a public interest litigation, it is a personal interest.
Yes.
He must have a locus standi. What? First, he must have a graduate. Then he has got the qualification. He must within the age limit. According to her, he is a scheduled caste. Okay, I am taking. Second is minimum physical measurement. 5 feet 8 inches height and 60 kgs weight. And this question has not been answered in the affidavit. Number one. If that minimum qualification is not there, whether this type of writ petition should be entertained by your lordship. Number one. Number two, there was a post of sub-inspectors.
That will have to be examined in detail. that superfluous argument will not do.
Yes.
You will have to substantiate the classification based on the standards laid down in Anuj Garg's case.
Whether the
2008.
Bobita Punia judgment is applicable, I'm here.
We are saying Anuj Garg, you are saying Babita Punia.
Yes.
Babita Punia is a different issue.
Yes.
There they were already short service commission, whether they were to get permanent commission or not, that was the issue. They were already in service. For 4 streams they were allowing, then the Union of India itself came and said we are allowing in 10 streams. That issue that he is not harping upon. He is saying the scrutiny to sustain a classification in terms of judgment of Anuj Garg in 2008
Oh, yes.
SEC.
But Anuj got the issue of the judgment, entire restriction in a liquor business.
That we have to see. We are only saying you are proceeding with the recruitment process, then how her right will be safeguarded.
Can consider. But when he is approaching this honorable court for interim,
You are saying otherwise he is not qualified.
yes, other is not qualified.
All this issue has been clarified. We have seen
Yes,
so
my
many
lord,
others.
only thing, my lord, which we have to
Yeah,
height,
said so in the
height, my lord, in armed forces, my lord, there is a requirement of height, my lord, weight and chest. My lord, inspectresses, my lord, I fulfill the requisite criteria. But I don't know, my lord, as because nothing has been specified for women, I cannot make an affidavit and say, my lord, I'm eligible. I don't know the requirements. It could have been 150.
But in the unarmed branch, they are allowing both.
Yes, my lord, that time I was eligible.
They are allowing both. So in the unarmed branch, since they are allowing both,
Yes.
is there separate parameters for both? Or
Yes, my lord, for male and female, there is separate parameters. And my lord, not only that, even for transgender, there is a separate parameters. Now, that being the situation, I cannot say, my lord, for sure that I fulfill the criteria for armed branch, as because nothing has been specified. Had that been a specification that this much criteria you have, my lord, then I could understand. My lord, it says chest. My lord, in a woman case, chest is not applicable.
No, women's chest is not measured.
It's not
Oh,
applicable.
not just
applicable.
the allegation.
That is what I'm saying, my lord, it's not
It
applicable in
does not appear from the petitioner has got requisite qualification mentioned in the rules, namely height and weight for sergeant and armed sub-inspector, 5 feet 8 inches and 60 kg weight.
But those are parameters fixed for male. How she can
No,
be asked?
fixed for, but there is no female candidate has.
Correct. So therefore it is for
No,
male.
presuming that she can apply. Assuming for a moment that she can apply. Not being debarred, not being debarred by the notification rule issued by the state government, that she has been debarred. But he must have a requisite qualification. Qualification means
When you have shut her out, how she can qualify?
why we have debarred? Because there are under chapter 10 of the Calcutta Police Regulation 1968, there are 2 types of combat and non-combat.
Sir, you are relying on 68 Act and he is relying on 2008 judgment.
2008 judgment is my responsibility.
Therefore, there appears to be a
2008 judgment in a liquor business. Liquor business judgment cannot be made applicable to the service rule. Kindly see the Bobita Puni's judgment, paragraph 4 and paragraph 33 and 74. Paragraph 4, judge advocates, kindly see the only 4 posts. Although there is a,
in that case, there is it is only concession of the Union of India.
no, kindly see, only respect of armed postal service, judge advocate general department, army education corps, army ordnance corps, army service corps, then army signals, intelligence corps. Only 12 forces cadets have been given the
Therefore, in
non-combat force.
In Anuj Garg also, it is not that they are to be allowed everywhere. But at the same time, the Apex Court has said a strict scrutiny of the proportion of classification.
Proportional classification.
That proportion, how you are saying proportionate?
Kindly see.
That is something which is to be seen.
But 2018 rule sergeant, so for post of sergeant, he has not challenged the rules. Without challenging the rules of 2018, he can challenge the advertisement. Number 1.
The advertisement also contains post under 2018 rules.
Yes. 2018 rules has not been
Surgeon
challenged.
is not under challenge, my lord. Initially,
How the process can be?
Lord, only thing, my subject lordship, kindly, my lord, I have challenged.
Can you tell us? If you have not challenged everything, then how it can be?
My lord, I'm only
one post in that advertisement you are saying is you are restricted. then the entire thing should be stayed.
No, I'm not on, my lord, I'm saying the surgeon post, my lord.
Then how? Yes, you are.
But I'm only beseeching, my lord.
Sir, unless that 18 rule is put into question, can you challenge the?
Well, it was as because it was not. I understand, my lord. What is that was not there in the tribunal, my lord. I cannot improve it here now. I understand.
What kind of order you expect from us? You tell us how it can be at this interim stage. Please try to understand what we are saying. Those who have applied under the 2018 rules, just think how they will be affected by any order if we pass it today. When that rule is not under challenge, that vacancy is not under challenge, we will stay. And can we stay a portion of it?
No, I have challenged the, my lord, the advertisement itself. Although, my lord, rule with regard to surgeon, my lord, this is the first time it came to my knowledge, my lord. The last occasion, my lord, senior friend. Yeah, I understand, my lord.
The advertisement itself, it says under these rules.
My lord, the advertisements, my lord, to very candid, it doesn't specify. It only says, my lord, one examination to be conducted where both armed, unarmed inspectors and surgeon.
But you are aware that now you have challenged the 23 rules,
Yes, my lord.
but you have not challenged the 18 rules. Then what can be done?
My
How
lord,
it can be stayed?
my lord, the 18 rules, my lord, 18 rules have been further amended in 23 rules, where the except surgeon, other rules were amended. Well, this is the factual position. I cannot say, my lord.
Therefore, whatever has been left
Yes, my lord.
under the 18 rules, if it is not under challenge, then the situation does not change from that day when the court passed an order that why you have not challenged the 23 rules. Now we will say why you have not challenged the 18 rules. Can we take a different stand than what was taken on the earlier date?
No, my lord, I was saying.
That stand having been accepted by you, you could have taken it higher that look, it's not my concern which rule, I am concerned with the rule only, with the advertisement. But you have acted, but you have omitted to take appropriate steps for 18 rules. Then what can be done?
Well, leave it to lordship kindly, my lord.
You want a stay, therefore we are asking.
I understand, my lord, what your lordship is bothering, my lord. Lordship is that whether lordship can stay, my lord, a part of the examination or not. That is what lordship's concerns are. I understand, my lord. But my contention is this, my lord.
We are finding a case, arguable case to be examined, but for interim order, how we can please show us something, whether we can pass such an order in such a circumstance, where the rule under which the advertisement is issued is by choice not challenged, because you have challenged only one.
That's true, my lord. I cannot improve it.
Then can we stay the entire recruitment process?
What is bothering you, lordship, is in staying of the entire recruitment process.
And can we stay just one post? That will just disrupt everything.
Understand, my lord, but my lord, what was not there, my lord, I know, my lord, I cannot come with further thing.
Therefore, we are asking you, what is it that you expect from the court in this circumstance? What can be done? You are here to assist, therefore we are asking.
That's true, my lord.
Then it becomes an academic issue.
I understand, my lord, what your lordship is bothered, my lord, is how can the examination be segregated with the surgeon giving the examination, others been left
We
out?
are asking you, what is troubling our mind, what is the issue arising? We are posing that question to you. Therefore, there is a stalemate kind of a situation.
It's absolutely stalemate situation, my lord. In what hand, my lord, I may say I have made out some case, but my lord, without challenging that rule, my lord, I am somehow, my lord,
I have already
handicapped.
observed openly that there is an issue requiring consideration.
Your lordship has said, my lord.
We have said so.
Yes, my lord.
But look at the situation. What to do now at this stage? Because it affects the rights of at least lakhs, maybe I may have applied, we don't know how. Usually it is in lakhs.
Most probably this will be the first case in Calcutta. And so far police force is concerned. All over India, I have noticed there is no post of sergeant, there is no post just like here with a horse.
Then there you are mistaken, sir. There is mounted police.
Mounted police Calcutta, only Calcutta.
No,
in Bengali, only in Calcutta.
Oh, in my parent high court that my state
Patna has got.
Yes.
But in Bengal,
mounted police in the BMP, Bihar Military Police.
Bihar Military Police.
Yes.
but in Bengal, only in Calcutta, not in other
Not
parts.
in West Bengal.
Not in West Bengal police. And this is only by the British region. And that is headed by a IPS.
Right now, there are 2 stages. At this, there will be one more stage. We'll fix it for hearing, final hearing.
My lord, your lordship, my junior is saying, my lord, I may be saying, my lord, your lordship may decide the issue today itself, my lord. If not, but they may go to the Supreme Court, my lord. I do not know, my lord, what will the outcome.
Without,
I understand your lordship's predicament, my
want
lord.
to press without challenging the rule, you can do so.
My lord, I understand your lordship's predicament. Your lordship is saying, my lord,
No, not only for the purpose of interim order. We are saying for your relief also, if you want to proceed without challenging the rule. Challenging one rule, not challenging the other rule. That is a conscious decision you have to take. We understand.
Segregation.
We understand his enthusiasm. We are asking you.
That's true, my lord. I have to challenge unless I challenge the both. I understand, my lord. What lordship is saying is absolutely right, my lord. I understand. I cannot.
This fact came to our knowledge right now.
That's true, my lord. I cannot took it in a piecemeal manner, my lord. I have to challenge the whole thing, or my lord, I have to leave it for the
You
whole.
have to leave it. How can you do it like this, Senator?
My lord, what will you be thinking, my lord? Public worship, kindly, my lord, if your lordship grants me leave, my lord, let me file a supplementary challenging the rule, supplementary affidavit challenging the surgeon rule. My lord, I may be not pressing the interim order today itself. My lord, if it can be taken up on Monday or Tuesday, my lord, by this time, if I, my lord, or my lord, your lordship may give me some protection, my lord, interim protection, or any day.
In the original application, he has not filed. How the original application can be amended here?
No, since the tribunal is non-functional, therefore that objection we don't know how far it is sustainable. The tribunal was available that.
No, I'm not saying that.
Yesterday, my lord, certain thing happened, my lord. My lord, it's not of this court, my lord. My lord, a Group 6 application was moved before the learned single judge. The learned single judge says, my lord, this cannot be the tribunal. What you have to do is, my lord, same tribunal issue, my lord. It's around 1 o'clock that has happened. My lord, the learned judge says, my lord, that it cannot be tribunal. So whatever is there, you move the tribunal first. If you are dissatisfied, go before the division bench. But I'm not going to take up those cases. Now, this being the situation, tribunal is defunct. Your lordship knows, my lord, 392.
How you can go before the groups?
I was there, my lord. It's not my petition, my lord. I was also, my lord, looking into that. So his lordship says, my lord, it cannot be done. So only option is, my lord, before your lordship.
No, when tribunal is non-functional, then that, but the way in which you have framed your case, the way it has been made, how you can proceed?
No, my lord, and another thing, my lord, my lord, if your lordship grants me leave, my lord, then I can file a supplementary challenging that rule. And my lord, your lordship can take it up.
Decided in 1 or 2 days on the last day, can't be done. See, already after 2-3 opportunities, you have been
arguing on the same issue.
No, you have been modifying or improving your case. Still, you have not got a full challenge to the issue. What do you expect from me?
That's true, my lord. I cannot say which is not there.
And the other thing is, since it is pending, even if it is taken up after the holidays, if we don't say anything, it will still be meeting. They know it is under challenge.
My lord, at least this, my lord, a written examination will take place. My lord, I will say, my lord, a subjective written examination will take place, even if it takes place on 30th. My lord, it won't be, my lord, the results won't be published, my lord, at least.
Therefore, we are saying result will not be published, plus mere participation, whether it will create a right, all those things will have to be considered.
Yes, well, that has to be considered again.
So therefore, we can consider it if you want to bring on record that prayer.
Yes, I want to bring
by next week, then you will have to give it to them.
Absolutely, madam.
So then it can come only after the holidays. Therefore, we are
May I suggest one thing?
Yes.
Your lordship can issue the decide the validity of the rules or the advertisement after election. But so far as the present 2023 election selection, she cannot pursue because she lost the 2 chances. If she applied in the next vacancy, a government may consider it condoning age bar. That is my suggestion. Kindly don't give me my concession, but this is my suggestion.
My lord,
Or
don't
he-
know when the examination will take place. My lord, then, my lord, they will come say, now your age, but 32 was the limit.
We'll keep this in mind on the next. If we forget
No,
to
but
remind
to
us.
solve the problem, to solve the problem.
No, we appreciate.
We are friend of the court.
We appreciate your suggestion. We appreciate anything that you say or he says. We have to. That is what we are here.
The next election, if she applied, she can apply.
What is the name of the 2018 rule?
My lord, that is in the affidavit they have said, my lord.
My affidavit are annexed at page page 33.
Page 33.
Yes. Page 33
My lord,
of
that
my
is
affidavit.
18, my lord, is called the combined recruitment rules of sub-inspector unarmed branch, sub-inspector armed branch, lady sub-inspector in West Bengal police and sub-inspector armed branch.
So some vacancies are covered under this.
Yes, my lord. The surgeon vacancy is covered, my lord. Only
Combined recruitment rule of sub-inspector, unarmed branch, sub-inspector, armed branch and lady sub-inspector.
And
Such a big name.
my lord, that is with regard to my lord, with Bengal police and my lord, and sub-inspector armed branch, sub-inspectresses unarmed branch and surgeon. But the surgeon word is there, my lord, that is required to be challenged. Now, my lord, with regard to the armed branch and unarmed branch, my lord, 23 rule came into force, my lord, leaving behind only surgeon. Surgeons are governed by
File
that.
it by next week. Give them a copy. We'll keep it after that.
After a date.
Not to publish result.
We file it. Learned advocate for.
Without the leave of the court, my lord, I'm not saying publishing, my lord. They should not proceed any further without the leave of the court. That may be there, my lord.
Cannot be done, sir.
Or my lord, then my lord, it's first or second week of January.
All right, we'll keep it on 20th January. 20.
At 2 p.m.
2 p.m. matter item number 67. 67.
Petitioner has not been able to make out. Petitioner has not been able to make out a case for regularization. In the facts and circumstances noted above, we find no infirmity in the learned's decision of the single judge. The same requires no interference. Appeal is dismissed.
Item number 32.
Uh, 32, my lord.
We are informed. SP is not going in. Yes, it is not. We have the difference. Yes. Already comes to mind. For specific reason for such this kind of discrimination. Such things. It's not that SP is not required to be. There is no distinction. They may be considered activities, that's an activity they study activity. None appears on behalf of the 13.
20.
Two stages have already been over.
Item 34.
Same order, none appears for either parties.
Item 35.
Item 35, my lord, I appeal for the petitioner. My lord, learned government leader, Mr. Shapon Kumar Dattu is appealing for this matter relates to resignation, my lord.
So when are those matters?
Those are on 13, my lord, but in this matters, my lord, some urgency is there, my lord, as because he got some job offer.
Oh.
My lord, not in a government job, but a private sector, he got a job offer. My lord, that is the sole urgency in this matter, my lord.
There is any opposition filed?
No, my lord. 13 January, even other matter. No, in this matter, my lord, yes. This opposition has been filed, my lord. In this matter, opposition has been filed. Reply has been also been filed by us. And opposition on the same stand.
For the state matter, similar type of matter, your lordship has fixed the matter on 13 January, my lord. Similar type of matter.
Yes. Similar or identical?
Identical. Process is going on, my lord. For the recruitment, your lordship has other matter on 13th January, it will be taken up.
Is it identical to the judgment that we have passed?
Yes.
Yes.
Identical.
Honest submissions.
But kindly take up all the matters.
No, he is saying in this case there is some urgency. Because he has been offered a job somewhere. He can't wait for you to fill up the vacancies.
Those matters, my lord, which your lordship has fixed, my lord, there is no such offer letter, my lord, I said nothing.
No, therefore we are saying. You have said anything about this in your reply?
No, my lord,
That petition, there was no mention of any offer.
There was none, my lord. When the application was filed, I didn't got the offer.
No mention.
No, my lord, I didn't got the offer then, my lord. Later on, I got the offer. And when the original application was filed, there was no such thing, my lord. I couldn't have input.
No, in your reply, therefore we ask you in your reply, have you stated anything?
No, my lord,
it is something which can arise any day that we understand, but is it on record?
My lord, in reply, my lord, I have only dealt with their part, my lord, where this cannot be allowed to happen, my lord. Right? With regard to this.
This is the subsequent development, my lord.
Otherwise, to make a distinction in this case, when all other matters are being adjourned, to make a distinction in this case, there should be something.
Well, I understand, my lord, but referring from lordship, my lord, that had that been mentioned, all, my lord, an affidavit in the, it's that's there on.
Then we may have proceeded.
Yes, I understand. I absolutely.
Because it is more a concession on your part in the other cases that you have allowed it to be adjourned.
Yes, I
not as a matter of right by them.
Yes, your lordship has said me.
Because you chose to buy your peace that unnecessarily will be running after this. Here the issue is different, then that difference must appear from the.
That should have been there, but it's not there, my lord. I'd leave it to Lordship, which is not on record, my lord. I can say, my lord.
Private, they will allow you.
Most likely they will do, but now, my lord, the problem is this, my lord, what is happening? Now out of court, my lord, this is the private companies, my lord, as because, my lord, in terms of, my lord, National Medical Council, whatever rules that they have, once an employee's name is there in one, my lord, he cannot be taken to any other post. Realize that. If I can practice privately, that I can do, my lord. But if I have to join any institution or any other thing, my lord, if my employer ID is reflecting in one sector, my lord, in one profile, my lord, I cannot have second, my lord, employment in any other institution. There is a problem, my lord.
According to my instruction, my lord,
let
interviews for the various posts under West Bengal Medical Education Service are going on, and interviews will be completed by the month of December. So, my lord, sometime.
Well, I will ask my client to, my lord, proceed, as because he has got certain offer, he may have consultation with them, my lord. Let that be the first week of January then, in this matter at least. December, if things are sorted out, hopefully, my lord, I don't have to, my lord, do anything, my lord. What your lordship is, I will have my peace. My lord, things are settled.
We understood that day why you
It's not like it's no
why you relented. We understood.
Interviews
Because in the other cases you have been made to file 2-3 cases.
Yes, sir.
Ultimately achieve that goal. So you thought instead of doing that in one go, it will be finished.
Yes, my lord. At least thereafter I will feel but to
Much
do
we
so.
understood.
Yes, my lord.
Interviews will be completed by December, but after that, some procedures are there also, my lord. So kindly take it up all the matters on 13th.
Let it come together.
Yes, my lord. Then, my lord, all the matters, there's series of matters, my lord. Should I give the numbers, my lord? All the matters on 13th.
No, after this, as and when they are taken up, if they are not
Yes, sir.
taken up by after 13th, if they are taken up, they may be
As well. আচ্ছা পরপরই আছে এক্ষুনি হয়ে যাবে
other matters similar to.
And 36.
36 same, my lord. Well, there is no such thing, I may say, my lord, offer letter is there, but let that be on 13th. 13th. 37.
And 37.
I have some.
Yes.
So, what I was submitting, my lord, there were reference of certain memorandums. On the basis of those memorandums, the claim for compassionate appointment was rejected. Now, I had searched, I had got out of 4, I have got 3. One memorandum till date I could not find. So I also asked some persons if they can get it. So if your lordship permits, my lord, any day either in the next week or my lord after vacation, whichever suits my lord. Because unless those.
Which memorandum are you searching for?
My lord, this is memorandum, my lord, I tell you, lordship. My lord, just 1 second.
You have the date.
Yes. My lord, this is. My lord, just I. reply. In the reply, I have referred to all the memorandums which are applicable in page 3. Now, out of this, one I could not get, that is memo number 4184 hyphen F dated 8/8/2016.
8/8/16.
Yes, 8/8/2016. At page 3 of the reply,
It is not having a number with EMP.
no. Oh, those things I have got. Those all things I have annexed in the.
Because it's not there in this compilation which Mr. Mukherjee gave us.
Amendment of a particular clause regarding the medical service post recruitment rules. This is a.
So this is not a memorandum dealing with compassionate.
No, this is a memorandum which is an addendum or a corrigendum to the notification dated 2009, which is the West Bengal Service Group B post recruitment rules of 2009.
So then help us.
Yeah, I have only one copy.
Therefore, we are asking you help us. Give us 2 copies.
I shall do that.
And you can share it with the learned senior pastor. One office.
F.
If it is legible, please share with us also.
The affidavit in reply may be kept on record.
Yes, affidavit in reply is taken.
8.
Same resignation matter of doctor.
Same 13 January.
39.
39, my lord, this is a, my lord, your lordship may recall, my lord, one proceeding was drawn up, my lord, by the vigilance, where it was dropped that matter, my lord. My lord, no affidavit is there, although there is no direction for affidavit. My lord, your lordship was granted me the interim order till, my lord, till 22nd of December. My if your lordship places the matter on, at least interim order be extended, my lord.
We have directed for filing affidavit.
No, my lord, there is no direction, my lord.
There is none to represent the state.
Item 40.
Appellant, my lord, led by Mr. Kolal Basu, my lord, he's on legs on other court, my lord, kindly grants not today, my lord. I'm just,
Not today.
my lord kindly makes this not today, my lord. He will
What is the issue?
Your Lordship, this is a matter where we were arguing the point of res judicata. Your Lordship, there was initially there was a matter moved by the petitioner claiming conversion. Thereafter, they had placed another writ petition on the self-same ground, Your Lordship.
The two are connected.
Connected matters.
Then let it.
Placed after the petition.
my lord, kindly makes it not today, my lord. My lord, he will address your thoughts.
You will have your adjournment and they cannot. A prayer.
Item 42. My lord, 42 and 43, my lord, same doctor resignation. 13.
Same order, 13 January.
43. No, my lord, 43. 42. 43 কি দিচ্ছে?
43 plus health has accepted his resignation.
43 you are okay.
Yes, madam, I'm also happy. They have accepted.
Already accepted.
Yes, Your Lordship.
That will get us.
কোনটা 42? 43.
আমি করেছি
Vigilance clearance. But they are said, my lord, they are waiting for the vigilance clearance, my lord.
That is the standard in every.
Yes, madam. Let that be done within a time frame, my lord, whatever time they want.
In one case, we have.
Yes, my lord. 4 weeks time you'll have to.
The issue arises.
And 44. 44, I appear on behalf of the petition. This is the matter of Public Service Commission which your lordship heard with regard to recruitment of the junior engineers. Now, my lord, after your lordship heard, then, my lord, my clients, my lord, showed me certain documents which had not been annexed in the writ petition supplied under the, my lord, Right to Information Act. Now, my lord, I very respectfully submit, my lord, if your lordship permits me to file a 2-page supplementary affidavit only annexing those documents.
The learned senior advocate.
And 45.
Come for the petition. My lord, I'm praying for not this week.
As prayed by
No, no.
affidavit. You are required to file the opposition. Then the writ petition.
And 47.
My lord, I'm for the petitionary lead by Mr. Udar Shankar Chattopadhyay. On the last occasion, my lord directed the state to file an affidavit of opposition, but the copy hasn't been served upon us, my lord.
Give it by 23rd, same order. Item 48. You are for?
Yes.
I'm for the petitioner.
Yes. Okay. So there is a 3-month delay.
Yes, ma'am.
Around 2 months, 21 days, it has been quantified. So this order was passed when the matter was still pending before the tribunal.
In my lord, 2016, my lord, a pseudo anonymous complaint was made against the petitioner.
No, this order of 25/7/23.
Yes, my lord. That was passed by departmental proceeding was pending.
No, at that time the OA was, after that the OA remained pending.
No, my lord. The OA was disposed of by directing that the departmental proceeding shall be concluded within 6 months. Otherwise, the departmental proceeding will be vitiated.
Then why it says then otherwise the tribunal may consider the entire departmental proceeding as null and void? If it is not pending, why does it say that the tribunal may consider null and void? Where is the order of 25/7/23?
My lord, that is at page 140. My lord, the ordering portion at page 141, my lord, third paragraph, my lord. After hearing both the learned counsels and considering the judgment of Apex Court in volume 420, 2015, SCC page 16, the respondent number 2, the additional chief secretary, Department of Forest, is directed to conclude the departmental proceeding against the applicant within 6 months from the date of communication of this order in the light of the judgment passed by the Honorable Supreme Court as mentioned above. And in the event, if the disciplinary proceeding is not concluded within 6 months from the date of the communication of this order, the tribunal will consider the entire disciplinary proceeding as vitiated.
So did the tribunal consider it after that?
And thereafter, my lord, the way was disposed of. And my lord, the order was communicated on my lord 26th July 2023. Communication letter is at page 142, my lord. After, my lord, the department disciplinary proceeding was not concluded within 6 months, so the petitioner filed another application before the state tribunal.
Then?
What's the proceeding?
Oh, then this order has been passed. November. তাহলে 21শে নভেম্বর
My senior has arrived.
Yes.
30.
2 months and 21 days delay.
That is them. So whether that is condonable or not. That is a question.
That is why we asked him to place the order, earlier order C, that order of
Second order,
25/7/23.
page 140 is the first order of.
Yes.
That certified copy of the order impugned is annexed to the appeal. The direction was initiated within a particular date, 6 months. That expires. Then we go to CAT. That's a mistake. That's a mistake. I should not have gone. Because the first order records that if it does not come within the window.
That is why we were asking.
Yes. That's a mistake of my. It's a legal advice. Clients go to court in legal advice.
We understand.
So now when they came to me, I said that I also asked them the same question, that why did not need to go to the same
No,
tribunal
but
again?
it's a rather unique order, if we may say so. You see the last, it says, if it is not done, the tribunal will consider the disciplinary proceeding as vitiated. It does not say it stands vitiated. It said I will consider it as vitiated. So probably that is why they have gone back, that now you consider it vitiated. Then he says, I have seen there is a due diligence. There is a delay of 2 years, 2 months, 21 days.
Something which
You have given him the opportunity.
That is something that I also inquired with my client. They said I followed my lawyer's advice at that stage. But
so what happened after that? What is the date on the punishment was awarded?
It's not salary deduction, no promotion. Those punishments are there. Those are.
Where is the order of punishment?
But after this, but this is not dated. This is not dated May. I think 2 days after this date.
Is it on record?
Yes, but it is on record. Dated April, but we received it on after this order. Page 242. Volume 2. This last 243 last line is the.
(2004) order. 24.
It started in 2012. In fact, it goes back to that more than 10 years that actually the proceedings are continuing. So that's a point that I'm also raising here.
It's a major penalty.
Yes. But 2015, the allegation goes back to the year 2015. Allegation is that in order to help some my own friends in that area in Vishnupur, it's in the district Bankura, I sold some locks, old locks of the wooden locks at a below reserve price. That because of that, after 10 years, they're punishing me now. When the order of site already says that unless it is done within 6 months, and that 6 months would also be beyond say 10 years. January 2015 is the incident. Thereafter, a pseudonymous complaint. In after 1 year, the complaint itself is of after 1 year. In 2016, I received the complaint. It was forwarded to me by the authority after 2017. 2019 up to 2019, no proceeding initiated. Then the proceeding was initiated. Nothing happened till 2023, and then suddenly this. This is the grievance, is what I'm addressing, that if there is no other finding against me in these many years of experience.
So what was the relief prayed in the second way?
But the actually, it is the prayer is.
Where is the prayer?
The court had gone. We have gone wrong. 150. Final prayer. Interim. 152.
152.
Prayer itself is such that it was such that probably that is why the court granted them for the prayer A mandatory page 152. Prayer A I'm reading that. Volume 2. A mandatory order of order do issue, thereby setting aside or quashing the entire disciplinary proceeding. That is such and such. Second show cause notice is such and such, along with the inquiry report, with immediate effect, as the same stand vitiated as per the order dated such and such. The moment we asked it, the court said if it is all.
Before we asked you what is the prayer, we thought that it was probably
should have been.
You could have straight away written to them that we do not take cognizance of this. We will not.
In fact, nothing else should have been done by my client. There's one line to written to let.
Now that there is a proper order of a disciplinary authority imposing punishment, without going into merits of the order, can we?
I can also take your lordship through the merits of the order, but my primary argument would be that if on this aspect, if lordships consider this aspect, that in a proceeding which is initiated in 2015 and is ending in 2025, if such is not beyond their jurisdiction, then what could be is a question that I'm asking to myself. 10 years they took to complete a proceeding, despite there being an order of SAT to complete it within 6 months after 8 years. After continuation of this for 8 long years, finally the SAT says you do it in 6 months. Even then they can't complete it. And then
up to January 23,
yes,
you have acquiesced.
I have acquiesced.
Up to January 23.
Not really, because I went to SAT and that was my complaint. There is continuing.
No, but SAT gave it till you could have challenged that order. Why for the 6 months?
Could have, but
you have accepted it.
Yes, I have.
So till December 23, you cannot complain.
I'm not complaining. I'm saying
after December 23, 2 months, 21 days delay.
They show it of April, but actually I received it in May. After
but the order is dated April, so
yes, they
maybe it will add a week or so more. That will hardly make any difference.
Now, but that on that aspect, there's one lordship is aware of that, right? Its maximum period is 1 year, within which it has to be free. Now, that courts also have held that in a disciplinary proceeding, once if it is vitiated, it cannot be reopened. That those judgments are also there. Now, even thereafter, the question I will obviously I'm ready, and I have taken those points in my appeal that even on merits, whether on the basis of a pseudonymous complaint, the complainant is still till this date not known. Who is the complainant?
So then let us go into the merits.
Lorships can go into the merits.
That may be bit.
Then Lordship gives me an opportunity to bring supplementary affidavit, because there are documents which I want to be carrying it, but the supplementary affidavit obviously If lordships want to go into the merit, they have to place.
No,
this.
we'll have to consider both aspects together.
Yes.
If you want to press both, if you just want to confine on the two orders, then if you want to go into the merits, then we are willing to consider everything. You are saying that it is a pseudonymous complaint. You are saying there is an issue of delay. Therefore, we don't know what other infirmities are there in the proceeding. There may be, they may not be.
That
So
I
if you
will
want
try to clarify
to,
myself.
then we'll go into the entire thing. Huh? So he will take an objection.
He will take, surely he will take that.
That's his job to do it.
That's not. The department is not that hostile to my client, my lord, because they are still, he's one of the best performing officers of that department, lord. So I don't think.
No, but
my
the
learned senior
punishment
friend-
is not a very, it's a major punishment.
Yeah,
It's 3 years and increments and everything.
salary cut, and lord, he's losing his chance to, lord, be promoted as
He's
IPS
still in
officer.
service.
Yes, yes. He was
Oh,
about,
this matter was adjourned and you were mentioned.
I mentioned, the lordship said that day I was not there. So he had a chance, he still has a chance to become IFS officer, lord, being promotion. But lord, because of this, that's also, lord, he's losing on that as well.
So what do you want to file?
That there are some documents.
It's ready, you are filing it.
But I'm carrying it, but supplementary affidavit is not ready. I'll take 2 days time to bring it on record because documents are all in hand.
Give him a copy.
I'll give him a copy. On Friday or Monday.
Obviously, he will have to file it on affidavit. It was not before the tribunal, so he will have to file it on affidavit.
The tribunal.
No, it is.
No, here, Millard. I was not, punishment order was not known to me. How could I challenge it? Where 152 is when I go there.
No, but then the order had not been passed.
I did not receive the order by that time, sir.
You please read paragraph 9 on the next page. We have seen it, therefore we. At that time, it was still going on. No, but he said not to proceed further. That means then it was not passed. That order was not passed. Two? Yes. That we have seen that 3 increments have been withheld or something like that. Yes, 82,000 or something amount and. Allegation is always serious. The point is whether the authorities have pursued it with due seriousness or they have done it casually. That is what we have to see. Those figures are always thrown up in the courts. We know that. It's not a big deal. If it was such a serious issue, then you must have proceeded with due diligence and done everything in accordance with it.
The judicial authorities are that highest period is 6 months within which it has to be.
See whether he has pleaded in the OA or not. The tribunal has taken cognizance of the final order.
It has taken cognizance. That's page
The
3
tribunal
of
has
7.
taken cognizance of the final order. It has decided the issue regarding the final order. Therefore, 2 months, 21 days. So let him file, we'll see. Give him a copy. We are informed by the learned advocate. times, I remember because you were very, that day, concerned about what had happened.
I'm grateful.
I have come from there.
Lordship had told me that day. Lordship had
I
told.
know I can't narrate the incident, but this is how we evolve. The SEO was telling the Honorable Judge that no, it is my fault. He said, no, the order has been passed. File a resolution. He had to. '28th is WPST will not be taken up on 28th. After 26, let it come on 27th. What is the? You have any personal difficulty? 12 with us.
That maybe if service be taken on.
Service. 27 or
27 exactly. 27 not quite. It's December.
Item 49.
I'm grateful.
One hearing was mistaken.
I appear for
Some other four. Mistakes. File restoration.
Lord, again, resignation, doctor, on the ground of doctor rejection.
13 January.
My instruction is, Lordship, that because of the shortage of teaching staff in medical colleges, that's why the is not accepted, Your Lordship.
You should just hope that by 13th it is done. Just imagine the amount of litigation that you are generating unwanted. So many cases are fixed on 13th. That day you will have to answer it. By then it is not resolved because the issue is decided repeatedly on the same issue, and as state you are generating such litigation. So we had given one opportunity because the learned GP had submitted that most probably it will become infructuous, and they wanted to buy their peace. But we hope that this does not continue till 13th.
Lordship, I will.
Item 50.
The last order, Your Lordship, delivered judgment, petitioner wanted to show some judgment. Kindly seize the order.
Lord, I've been told, my Lord, Mr. Shubhobrata Bandyopadhyay is appearing. My Lord, he is some difficulty. Can it be not today, my Lord? I've been told, my Lord.
Not today.
Not today, my Lord.
Not today.
As Your Lordship.
Item 51.
Not today.
Item 52. 53.
There was a direction for fresh service since earlier service was not affected. But I saw, but I could not affirm the affidavit of service. Only not today, only tomorrow.
Not today. 54.
Time for respondent, Mr. Achin Kumar Manjumdar, he is injured. Praying after vacation.
My lord, yes, he have fallen up. We know that.
We are informed that the learned
Huh.
7th January.
Much.
Item 55.
I'm led by Mr. Arijit Majumdar. Kindly the short pass over.
Not today. Item 56. 57. 57. Who is appearing? You are appearing. You are appearing in 57. In 55, I was appearing. It's over now.
In 57, I am for the respondent. Lordship 57, I'm led by Mr. Arijit Majumdar. Lordship.
By?
Arijit Majumdar. Lordship, he's for the Union of India. Kindly grants a month's time, Lordship, for the paper book.
For paper book. There is a direction.
There was a direction of the for filing of a paper book.
In August, there was direction to prepare a paper. And that is to be active month of November.
Lordship, the required documents are not yet available, so it's becoming a bit difficult to make paper book.
After dictated. After
You file your opposition.
I'm particularly not in this matter.
That also not filed. Why? Union of India.
Lordship, I'm not in this matter, Lordship. I just have the instruction.
So you are appearing, but you are not appearing at the same time.
He's engaged in court number 1, so I'm just appearing on it.
Why such a lackadaisical attitude is taken from August? This is the case of a deceased employee. The coordinate bench has fixed it for final hearing. Very old matter.
yes, madam. This is the case of decision in 2003. She had the personnel holding the post of cook was dismissed in 2000.
Holding the post of cook.
In the dismissed in 2005. So I have also my landed page and also kindly grant me 1 week after that.
I jointly prayed list this matter 1 week. Appearance. Item 58, 59, 60.
Item number 60, that a primary school teacher, he was absent from 2016 to 2019 on medical ground in the school. Well, thereafter he wanted to join. The school did not take any decision. School referred it to the director of school education. Well, it is via district primary school council. It has gone to the director of school education. Director of school education, when the decision is pending, my lord, I have not been allowed to join up to 2024. I filed a writ petition before this honorable court for the purpose of allowing me to join, because I have neither suspended nor disciplinary proceeding. I was ultimately, my lord, detected cancer.
You filed the writ petition in 24.
It is a case of 2024.
Writ petition.
Writ petition. 2023 writ petition.
Then what happened?
That writ petition, when came up for hearing, the honorable court said, my lord, the trial just said that initiated disciplinary proceeding against me. It was nobody's case that I have been charge sheeted, by a charge sheet will be done, whether I will be condoned the delay in joining the school. That 3 years, my lord, absence of me will be treated to be a, my lord, unauthorized absence. I am agreed to that, whatever way they want. But the court said that initiated disciplinary proceeding, my lord, because of non.
So the period of your lapse, you are willing to forgo. And the
my lord,
period of delay on that, their part, you are not willing to forgo.
I am today, my lord, I am willing to forego my service even. But let me survive, my lord, with my retail leave. I have, to my credit, I have more than 21 years of service. But if I am not, my lord, quarreling with the authority.
So till filing of the writ petition, there was no charge memo.
No charge, no disciplinary proceeding, no order of suspension. Only I have not been communicated any order.
And where is your first application for joining?
In 2019.
Where is it?
I am saying. First initial appointment.
No.
Join, yes. Yes.
You said that from 14 you were.
Page 56.
16 to 19 you were absent.
My lord, Lordship will get it at page 57. The authority is admitting, page 57, that the client, my client is wanting to join. Page 57. Because previous page is a Bengali page, I will not show it to you, Lord.
Why? Give a translation.
That has not been done, my lord. So that may not be required because page 57 is accepting my prayer. The district primary school council is saying. It comes to know from the application 3rd October 2019 that so and so that he wants to join the school after a long absence on and from 3rd November 2016. Permission is not accorded to join. You are requested to explain whether his absence for long period was reported not to the appropriate authority or not to the. So ultimately, my lord.
So after that, nothing was done.
Nothing was done. No. Page 18, if your lordship kindly come, the reply given by the school authority.
18.
18. That was the explanation given by the school authority to the chairman of district primary school council. And thereafter, the council referred it to the higher authority, Commissioner of School Education, page 19. Finally, I was detected cancer in 2021. 21. Page 21 is page 19. Yes. 2024.
What was your relief in the OA?
Page 34, the relief rate in the writ petition, praying for joining, allowing him to join the duty.
This is the order passed by the Honorable Single Judge.
The improved order is at page 16, 16.
Proceeding has been initiated
Nothing.
after this order.
No, nothing, nothing done.
You have up-to-date instruction.
My lord. My lord, in pursuant to the order passed by the Honorable Single Bench, my lord, they have taken a decision to initiate the disciplinary proceeding. Kindly consider, my lord, please.
No, till date charge memo, whether it has been.
That an instruction I don't have, but there is a memorandum issued that they were going to initiate a disciplinary process.
All right, it is in contemplation.
Yes, it's
Not-
contemplation. I should be candid before your lordship. 2024, after passing of this order, 11 September 2024, there was a my lord decision office order that we are going to initiate a disciplinary proceeding.
No, we want to know whether till date it has been issued on.
Yes, my lord, that instruction I need to take. That instruction I.
Because if something has been done, then that will affect whatever we do.
Yes.
It is better to know what is the current status.
My lord, one thing that I want to point out, my lord, will consider. Kindly consider page 53.
Yes, what is it? Tell us.
My lord, 2017, 2016 onwards, he remained absent. 2017, the circle sub-inspector had issued a memo to the my lord petitioner saying that as you did not take any leave, it is treated to be an unauthorized absence. You are directed to explain your conduct. My lord, what he had replied, page 54, that yes, that is there. I remain absent.
He gave a reply.
Yes, kindly consider page 54. And he has said that let me allow to remain absent for further days. This is the conduct, my lord.
Reason C, this is sick.
Now
man
you have been
suffering
detected.
from.
You have been detected for cancer in 2024. See, my lord, and
This is now how the statutory authority treat it. I am not asking for anything. I have whatever I worked. If you have no proceeding against me, my lord, I should allow him to join either.
As soon as I am fit for my duty.
yes, kindly see. And
Ultimately,
that
my lord,
was
detected
continued.
cancer.
That was continued.
No, you are not. You are not detected with cancer.
The letter of the doctor is.
Please read the last two lines.
Yes, last line. I cannot say anything, my lord, what is not, what has fallen. I am not saying, but that indication is there. This is susceptible to cancer. I am.
There are many such conditions. It's
But
not
my-
a cancer. It's not a cancer. That we have seen the moment you said we went through it. And plus, it's not from a very
No oncologist. No oncologist. But be the resident.
somebody is bad saying that it is a pre-cancer.
Well, nothing has been done against me as on today.
Why you are absent for years and years and years? And how the school is functioning without you, and you are saying whenever I am fit, I will come and join. Perhaps that is why the single judge said you proceed against him. What is wrong?
Proceeding.
When you said we went through the certificate, does not inspire confidence that
That was the 2024 certificate given from 2020 onwards. He is suffering. He be that acid pain, my lord. I am not with the fortified with any certificate.
therefore we want to know whether charge memo has been issued or not.
Nothing has been issued.
We don't know.
Nothing has been issued. Let them come, my lord, on Monday with that instruction. Lordship may dispose it of on that. Or Friday.
My lord, only one thing. After Malord, this office memorandum that where they have taken a decision to initiate a disciplinary
Let
proceeding.
us see.
Yes, Malord Kaligast.
Where was he posted?
Malord,
In the Malda, district of Malda.
and 2016. Kindly consider the.
I
file of the
wanted to join in 2019, my lord. They are taking these all species in 2025.
And Malord,
I have taken 3 years, my lord. They have taken 6 years to deal with my application. You could have rejected it.
2016 onwards, what is his explanation?
The explanation not
He said that.
Not to the satisfaction of yours. I understand that.
He said.
You have
Malord,
not said so. You have referred
but
to the other
the student
higher
interest
authority.
is paramount, Malord. The student interest is paramount. A teacher is letting that student to suffer for years together.
This is not sustainable.
So after 19, after he made the application, did you tell him anything?
Malota, there are after Malota, when this application was issued, Malota, the reply they have given in pursuant to the.
Before the single judge, you filed any?
Malota, the single judge, because the single judge, Malota, considering the writ petition, Malota, single judge has passed the order.
This is a motion stage, my lord, that was passed. Order was passed.
Malota, Malota, the grounds that the persuaded the single judge, that single man judge has reflected in his order.
It's all right, but you have a copy or you have given us.
Malota, I have a copy.
So you refer to second paragraph. Page 8.
Yes.
How it can be till date?
Malota,
It can be till 19. After that, you are sitting over it. How it can be till date?
Because Malota, 2023, when the matter was taken up, he remained absent till that day.
Sir, when he has given an application in 19 for
Yes,
joining,
2019.
and you have started corresponding what to do about his joining, then
Yes.
how he can be blamed for that?
Malota, I am leaving to your lordship because.
But look, your decision is to proceed against him for absence till date means September 24. The date on which the office order is issued. How can you justify this? Those 3 years we can understand. You place it on record. You place your stand on record.
If that
We'll see.
yes, if there is some correction is required, that can because
Unless it is on record, unless he
Yes.
sees he gets an opportunity, we will not pass any order.
yes, Malord.
You place your stand on record. The submission of the learned advocate for the writ
Only one thing, my lord, as the period of absence, my lord, because it was such a long absence, we don't have any.
Under the rules, no stipulation.
We don't have any power to regularize or to, my lord, take a decision.
Who
That's
told
why
you
we
to,
have,
who told you to regularize?
my lord, that's why we have.
We are asking you to file opposition.
Yes,
We
my
don't know
lord,
what will happen.
I'm
We
telling
don't know what will happen.
Yes.
Even he doesn't know what will happen.
I can accept whatever punishment is coming, but my qualified service will not be wasted.
Prior to absence, you have the qualifying
20 more than
service,
21 years.
qualifying service accrued.
More than 21 years.
Then you should have been more careful.
And
sometimes one of the fate is.
Let's see, let them file, we'll see.
You do not keep it 100%.
No, sorry. Before filing of opposition, I didn't. Wonderful.
21st we are coming.
162. Not today. 163. Let us see. Where is the file? There. Sixty-two. Yeah. 62. 62. This is from the last file. Then give it back to the state file. He was supposed to take it back. 62. 62, Lordship. Or get up there?
They appear for him, Lord, the municipal corporation, Lord. Responded.
We have for respond number 8. Where is the order under appeal? Which page?
Right.
Paper book, which page, sir?
At page 54.
Yes, can you tell us? Page 44 and 45. 45 is restoration.
Both the order was passed on the same day, Lordship. The appellant case was that the premises is unauthorized. The corporation submitted a report. We will find the report on page 48. No sanction produced.
Maybe.
No sanction produced by the respondent.
So is it a PIL?
No, it is not a writ petition.
Then what is you have? There is no. The court has recorded. You have no concern with it. You are just bringing in the issue before the court without any concern.
Lordship, the thing is that even
go and you avail remedy in accordance with law.
Lordship, on the last occasion, if Lordship may kindly recall, Lordship asked me that there must be a building tribunal, there must be a provision.
We don't know. There may be, there may not be. You may go for a suit. There are so many. Why a writ petition?
No,
that is the issue.
Lordship, I'll
In
show
a
you.
writ petition, how we can embark on such an inquiry
Lordship,
regarding
I'm telling you.
legitimacy of a plan and whether it is in accordance with the bylaws and building rules? How it can be?
Lordship, kindly appreciate for
Locus of the person.
Lordship, locus of the person has been settled by Supreme Court. that even if you are a stranger to a property and if you find any illegally committed by and if the statutory the duties they are not fulfilling, they are not discharging their statutory obligation, then it is a duty of the person to bring it to the notice of the court.
For any building.
For anything, if I find.
For any building.
Lordship, kindly appreciate.
You are
If
trying to appreciate.
this
therefore
is not a title suit I'm asking for.
Exactly. This is not a title suit.
Not a title suit.
Not a civil court. Both.
Not at all,
Or
Lordship.
before a writ court.
We are only that we have when we complain to the municipal authorities to take action for such unauthorized use construction on the street, they will have to discharge their statutory obligation, Lordship.
This is not the forum.
Kindly see the report.
This is not the forum to embark on this inquiry.
Lordship, the writ court has enormous power to 26 to at least ask the authorities.
That has been done by the writ court. That has been done by the.
No, what the writ court, kindly see.
We have seen there.
Lordship, what writ court said, the report of the corporation indicates that the building has been in existence since 2006. That's all. But no sanction produced by the corporation or even by the private respondent. If it is not, if the premises
cannot be.
Lordship, I can rely upon 2-3 judgment. I'll give it to you, Lordship. And also on the last, I'm giving it. Just give me the breathing space, Lordship.
Yes.
On the last question, Lordship asked me that.
Sir,
that answer I've got it, sir. Also.
Court gone to the extent possible under 226. It asked the authorities undertook an inquiry, they placed the position that this building is existence since 2006. What do you expect the writ court to do after that?
Lordship, the explanation.
What do you expect? You tell us.
The expectation is there cannot be any erection of a building without sanction plan.
What do you expect? What order is the writ court to pass now? You tell us to demolish the building.
Lordship, kindly appreciate one thing.
What is it? What is the relief you expect?
The writ court has to expect from the corporation to give the sanction plan. They must have a record.
Sir, we are asking you again. What is the relief you wanted, which could have been given by the writ court after this situation? Tell us.
The writ court ought to have asked because this was not enough to establish that building is a sanction plan.
Therefore, a roving and teaching inquiry should
No.
This, under 226.
No roving inquiry is required. The corporation has to only place a.
That is exactly what you
the
are
municipal
suggesting.
corporation has to produce the sanction plan. That this is a sanction plan. The building is totally sanctioned, authorized. So we will not interfere.
That is
Or,
not required.
Lordship, one thing more.
That's not
The person who is guilty of the construction, he was also a party there. He also not produced a sanction plan. He just kept silent there.
He is not required to. This is not the forum.
Lordship, then I have to come with this judgment and some provision, Lordship. Otherwise,
give all
that.
Give all the judgments which you are relying on.
Sorry.
Place it.
Just give me 1 minute. Not this one. I gave you the judgment one, but should be ready with this. No. This is regarding the battery. Lordship, this one judgment is there, Lordship. The other judgment messed up.
On which point? What is the point?
On the point of unauthorized construction, writ was filed in the court. The writ court passed an order. It was challenged division bench. It went up to Supreme Court. Supreme Court has laid down that if there is an unauthorized construction, the writ court has to interfere and pass an order.
Any others? You said 4 judgments. Which are the other 3?
Lordship, the other judgments.
But there is the party interested party.
Which paragraph of this judgment you are relying on? This 2013-5 SCT. Which paragraph?
Lordship, just.
They were all interested in inside world. They were the beneficiary of the unauthorized construction.
No.
And they are alleging that.
We are not concerned with all that. That's not the concern of the report.
Lordship, from paragraph 8 onwards, the Honorable Supreme Court come with the observation. Paragraph 8 onwards. Yeah, the judgment they come. Okay. Yeah. On the point of? No, this is 226. My lord is asking why read court, why should the to all these other judgments messed up. Can I Lordship come back on one tomorrow, Lordship? It's all messed up.
Not really.
Here,
Here, my lord, important point is saying that government feels that he has been cheated. Then the question comes.
I'll give the judgment, Lordship, I'll come back on. And the building tribunal has got no such provision, Lordship, which I was asking. Lordship posed me that question on that day. There's no such provision.
Maybe not. Still, Red Court will not embark on this. We are very firm in our view. We will consider your judgment. If it can persuade otherwise, then we don't.
Lordship,
But we are very firm
Lordship,
in our
it's very rightly pointed out, it's a public interest litigation matter. Any cause anywhere can be taken up.
That judgment is relying upon the single judge who was inclined to go into the issue, had past orders.
So if that
Then
is
they travel to the Supreme Court. This is not the case here. The single judge has exercised his jurisdiction. He has found whatever was possible within the limits of the 326.
what is apart from that, if this point is upheld, anybody can take up any issue anywhere for any subject.
So there are contradictory judgments. I satisfy your Lordship. Even is a stranger also, common man, have no connection with the property. If something is illegally done in front of his eyes, he cannot shut his eyes. And
can approach the Red Court for getting
Lordship,
it.
I'll convince you.
That
I'll
too,
try my
20
best,
are
Lordship. Can you give me
enlightening us also? Please come with that. Yes.
I cannot enlighten you, but I'll that audacity I don't have, but I'll try to.
26.
The question of a locus standi.
No, that's not an issue of locus. Issue is of limits of a jurisdiction under 226. We are not concerned with locus. There may be other forums. Why writ we are saying?
Definitely.
Why writ?
I'll answer this thing.
Yes.
I'll answer. Can it be after vacation, Lordship?
We have no blood, but
He's just.
no, I am saying.
It's too much.
Difficulty, then take it up.
But next week I'll be traveling, Lordship.
As paid by the Learned Council for the parties list.
Item 63.
No, I am for the appellant in this, madam.
My lord, I'm being
Hard this,
led by
madam, the
Mr.
last
Basu, my lord.
occasion, the issue was very short. Malad, the development authority, the appellant before your lordship, and made a recommendation for allotment of land way back in 2012 in favor of the respondent writ petitioner. Now, in view of the impugned order by the honorable single judge, the direction was given to the development authority to hand over possession of the land within a
Yes,
certain.
on a recommendation.
Yes, yes.
Yes, so recommendation is binding. Under any provision.
No.
Then how a direction can be given?
That's why we are aggrieved by that order. We are the
No,
appellant.
so therefore the case is, there was a recommendation by the development authority to allot certain land. The single judge has said you give it.
Yes.
So therefore you are here.
Yes.
So we are asking you that recommendation, was it having any binding effect on the, if not, under which provision that recommendation is made? Therefore we are asking.
The land belongs to the state government. We are a development authority under a department of.
That we have understood from your submission.
Yes.
You are a area development authority. There is some government land. You recommended for giving him that land, but you did not give him. The matter remained as it is for quite some time. Then he approached the writ court. The writ court said, since you have recommended, give it to him. This is the case.
Yes.
Now, therefore, under which provision you made the recommendation, we are asking you.
There is no provision as per the Ashra policy as it was there prevailing at that point of time. If a person applies for allotment of a land, After scrutiny of their application and the documents.
So where this procedure is prescribed?
My lord, there is
You are the authority.
Yes.
You have taken the action. So what was the purpose of that action? We are asking you. It may be just a recommendation subject to affirmation by the state in some department because it is state land. It may be that once it is recommended, it has to be granted. What is the legal position that we are asking you?
The state government.
Facts we have understood. When you said we have understood.
The state government is saying that we have applied before the state government for approval at that point of time. Now the state government is saying since there is a change in the policy now, after 2012, the new land policy has come. Now land allotment has to be done through e-auction.
And this recommendation was made prior to that.
Yes, yes.
And the order has been passed after that.
Yes.
And before the writ court, did you use opposition?
No, it was only very motion stage. It was disposed of before direction. You can even explain the procedure, Malan, in para 16 of my stay application, what is to be done.
So that direction is, where is the date? What is the date of the order?
Well, 31st January 2024.
Without opportunity of response. Yes, without opportunity to file opposition also.
No. No opportunity. On the very motion stage, it was decided, without calling for any affidavits. Otherwise, we could have explained on affidavit like the procedure.
So we will hear the matter. You tell us the procedure.
I have explained the procedure in para 16 of my stay application. The procedure is.
No, you prepare a paper book. You get the paper book prepared. You
for the respondent, my lord, I'm being led by Mr. Basu, my lord. He's appearing virtually.
Yes, heard that.
My lord, may I say, my lord?
Yes, you may.
I'm sorry, my lord. Today I'm appearing virtually, my lord. What your lordship has.
No, why? Sorry, you are welcome to appear virtually.
I'm extremely grateful, my lord. My lord, what has fallen from your lordship, my lord, that is, my lord, the point, my lord, that I would, my lord, most humbly urge. Your lordship was correct, my lord, that absolutely always correct, my lord, that this policy, what they are trying to say, came, my lord, much after, my lord, when the decision was already taken.
No, even under the earlier system, what binding effect that recommendation had?
Exactly, and according to their own admission, it is not only a recommendation upon approval. The board has approved this.
But that's not considered by the single judge. There is no approval recorded in the order. Please show us where the single judge has held that it was approved.
That is the thing what your lordship is pleased to ask from them, because they have themselves say
without opposition such an order is being passed.
Your lordship kindly hear out the matter whatever you false from your lordship.
In the meantime, we'll stay operation of the order. Heard learned advocate for the party.
That is already there, that is already there.